Yes, my lord, this matter, public interest law number 139 of 2016. This public interest of whatever directly belongs to government land, my lord, and the pending, there is an urgency, this matter may encroach public interest litigation. But this public interest,
everybody is the public. Are you not public spirited individual? Are we not public?
yes.
So what is where what the group input taking place based on government land?
Yes.
You take it up on you have complied with all office of
Yes, yes.
it's
It's a pending plan. Pending plan.
what is then all of a sudden getting up a 3 PhD looking at
Not, we have been making some map illustrates, not the question of the review.
no.
We are
When we
waiting
say
for,
something, you should take it in a lighter way. We want to start the way on a lighter note. Nothing.
absolutely,
The property doesn't belong to you. Even if the petition is allowed to you, will not get the land. If you are,
That's
you know, after getting clearance, you will apply for Patna and you will get it thereafter. These are all lighter ways, right? So there's nothing in that way, right? Not in that case that tomorrow at 12:30 a person will be hanged by neck and we can't be brought back to this world. So therefore leave everything aside and here we are living. Not a case of that.
very dead.
It's pending since when?
2016.
6 years you have waited.
Yes.
That's what
Yes, that's what I have stated.
says that it's a pending litigation.
Yes.
2016 and what interim application you are trying to seek because it will not come up for final hearing like on a mention letter. For that we have been filing a hearing. And the law cannot be different for public interest litigation.
Yes, sir. I agree for that.
Yes.
Like they
What IA? Which IA you have tried?
any date,
Which IA who require consideration?
my lord,
We filed any idea for fixing a date.
no.
That is what the
Please file.
yeah, for
Please
fixing
file
a date.
and then say that it is not being
This
listed. This is what we have been telling everyone. Public litigation is no exception.
Yes.
Everybody here knows you ask them that for getting a final hearing of a case, they have to do an IA and then we decide. Depending upon our listing, docket and what is.
Very much more.
Please file. But thanks for the question. Don't seek a reason.
Last question. While Sigilkar is considered as local,
Non-local or local?
non-local. Instead of local,
Peak of time you have come, right? We have almost, the petitioners have concluded their submissions and Mr. Rao told us yesterday that it will conclude within half an hour, right? Peak of the time, otherwise you would have wait a complete.
here
Today. Yes, that's.
Let's-
Number 16 bylaws. We will adjourn it when it is called, not adjourn. So we should be granted of it. Fine. That's what you should say. 16.
So, here is the Open Court 6-party order.
Party order, what happened?
The parties are settling the matter, my lords.
Learning council for the appellate is submit that the dispute between the parties is likely to be amicably settled, therefore place for adjustment. So therefore he was the you for the appeal of the two of us. Yes. Yes. Because in which case it will be fine. Please, so that we can. We are not concerned with the number. That is not listed today. What next is the 30th August.
And one latest time petition Canada. The petitioner in Indian paper, the referral by updated as the order.
We take
One point latest time petition.
30th August.
Yeah.
30th August. 30th. Please. Yes. There's nothing is smart. There is a connected matter which is filed, which is pending in the registry. 1 week time allowed so that both can be heard. You tell us what can be the case. Please supposing if you are aggrieved by the closure of the case, right? You have remedies under CRPC 154, 156. One week time because the connected matter. But it will follow.
Covered by a decision of the Supreme Court.
Bring such fact case, not the closure of the FIR. You are not ready at home. We have ready for you. This intra court appeal has been filed against the order dated. This order dated when passed by the single T22, by which it by the contracts of filing of this legal done by by the
To mention an item.
Yes, but
Please, my lords. My lords, these are items 79 to 85, connected writ petitions,
Yes.
which are listed today. This relates to the Disha encounter killing, which led to the formation of a commission of inquiry. My lords had on the last occasion given permission to mention it. I only wanted to bring it to my lord's attention as my lord sees convenient.
this is 79 to 85.
Please, my lords, I'm appearing in 79 and 83. Senior counsel, Mr. Prakash Reddy, had been appointed as the amicus in the matter.
You are aware that 30th August is around the corner. So
Yes, my lord.
before us are in queue, we are hearing their this thing challenge to the rules, and we can hope to conclude it today. So I don't know how much time will it take, but you may not wait. And
I don't wish to burden the court. My lords may then adjourn the matter.
Ask for a date beyond 30th August. So
And any date after the 10th of September that is convenient for the court.
when you tell us your an outstation counsel, your convenience matters.
I'm very grateful for the indulgence, my lords. My lords would see if whether 14th August, 14th September, I'm sorry, 13th or 14th September, whatever is convenient for the court.
Yes, madam, 14th September.
I'm very grateful, my lords. I'm very grateful.
Party is present. Current senior counsel for the appellant is petitioner and appeared video conferencing this on 14th September 2020. 79 to
85, my lords.
yes.
I'm grateful.
This same order came back. Where is the order? Item 2 is covered by W number 814. 814. And the extent was already by same order. Covered. That extent is already admitted. That just pass on the proceedings. That's the submitted about. This same order 814. Item 3 is 815. Item 3 is matter 815.
This is the order. These are the victims.
The position in law.
But the position of the law, what is before that? It is not quantum. I love this particular difference with the learning, which is only one point of position, what we. But the My lords, diesel venture is some but that lords is similar. It goes to 1 lakh in one case. What diesel venture lord, they reduce the part of 2 lakhs. But diesel venture 1 lakh. Another case, value of the vehicle. From the department of the another case also not the imposing 2 lakhs for a green flag quantum. Otherwise, not able to 1 lakh has been distinct. 1 lakh has been that it's published as how much do you want? 1 lakh. 1 lakh is already followed, but terms not. They should not the vehicle. Otherwise, not the perpetuate not. Some terms not. Otherwise, the way unable to illegal enforcement.
Can be. Terms can be that they produce the vehicle and then required and public security. Case you want to have a right to your offices, make it available. Intervene, don't take it seriously. All of you are so serious that we are afraid. What are we doing? So that the value of the product is available. Now, how much security should we ask? 1 lakh. 1 lakh. You modify the order. No, that is sufficient. You cannot get away and sell the land and sell the vehicle and what were you doing? Why were you doing a forest land? Thinking that it's my land. I not. Suppose the tractor accidentally your tractor has been seized. If in this thing as you were going to forest land, para 6 of the office. We are maintaining that order, releasing it. But the subject to this has been more than this. May I make a submission? The tractor has been operated without you have sold the tractor. No. Because of the finance flood and the it's not online. How much is the value? How much is the value? Less than 1 lakh. Less than the value. Less than 1 lakh can be 1 rupee and 99,999 is also less than 1 lakh. And I confine my arguments only on the thought system basis for a minute. I confine my argument only 6 points. That the order passed by that the order passed by the respondent authority is not as per the provisions of the action. The order was passed as per the section 44. What is the value of the tractor? Now it has to be anybody who can tell us in the court what is the value of a tractor nowadays. It is an old tractor, not
Which year made? You tell me, I will tell you the value.
which year you had purchased the tractor? Which year?
It's about 30 months. 2010.
Will expire within 2 years. Government 10 years and not. Will expire in 15 years. Confiscation order exists. You don't answer the question, so what can be done? We are asking you, what is the value you did answer? You are down section 16. We told you that we are not interfering with the order releasing the vehicle. Despite that, you are arguing that it is illegal. You are not final appeal. The MBBS students are waiting, sir. I'm your doctor. Who will treat them if they don't get admitted? What happens? You will treat them, will no doctor. So, what is the value of the question? The exact value what is
That is fine. Some black is reasonable for a black for a county tractor is fine. I will tell you everything. Don't worry. That is reasonable. We are only asking security.
security, not about most of the
Not to eliminate, not to create any.
can product remember that not to do forest land. If you have brought it on finance, only most already 20,000 is not. Because you are not able to, they will record your submission, not able to do it. You should give the tractor. At least
will go to the direct for the disabled bank.
is and being a customer, is a farmer.
We will give bank guarantee.
Not in most
He need to have that cash amount which is the top account. You want to produce the bank account, what is the balance in this account? Account has on. Is very poor farmer, what is the amount? Everybody is poor. When it comes to making payment of money, everybody.
deposit the FDR block, we just go to the otherwise,
It's nothing.
they just not.
The farmer deposit of my amount to get nothing like already deposited 20,000. My submission lot first of all, and he cannot confiscate the vehicle as per section 44.
This is not an appeal fight by you. You cannot argue on merits of the case. But final appeal, challenge the order passed by learned single judge to a cause of action. We are surprised that appeal has been allowed, the writ petition has been allowed to your argument. That is understandable. That's a 1 lakh I can't afford. Please fix the
50,000 melodies. He said, poor farmer will not of this.
it's just by raising. No. What do you think you are buying a potato, tomatoes from a shop for bargaining? It's an order. Go to them. Don't bargain. Don't bargain. There is no financial condition. This is the focus.
Is a poor farmer.
I will. We will record your service. There, beyond that, nothing else you can do. Write an order, sign it, and give it to forest, GP forest. Write an order. At zero amount, government should pay you 50,000 per month, and execute the patta in your favor in respect of forest department. Write an order and give it to GP, sign it. This is not for the key, right? Yes, order date is 19 July 2020. I will. Forest officer, directed factor it is 60 80/20 on petition check the bond of this for the right some satisfaction head officer giving rise to filing of that. That the respondent
Not being a policy observation. Otherwise, not everybody takes the advantage of it. Should not be in all cases, but otherwise everybody takes the advantage of
The clear facts of the case. Nobody has got is another forest offense you have committed, you are right. No, plus. In that case, he will argue that not even 50,000 and no means even to pay 5,000.
what places civil very council.
Contrary to records, my next subject and challenging
If you get to the issue with 6390 2014.
my right is created
Yes,
now. But my right
Can you anticipate? Do you know what we are going to ask? Please tell an answer. You say what? Not asking. Yes, go ahead.
my right is created now. That's why I'm challenging.
Your case, but you wanted to ask, please ask.
My right is created now. Therefore, I'm challenging now.
What
Therefore,
challenging means?
yes. It's contrary to records. In the revenue, the village map as well as Traha rules, the multiple effect
We started to say you should remove your bands from the hand. Please behave yourself properly. Please remove your bands from the hand. Can you not keep it properly? Put your gown on the chair. Let the court properly. Please. We can understand your aggravation that your lands are being taken away and being shown as FDL lands. But that doesn't mean that you give it over to all decency decorum.
if the
What is the proof you have enclosed to show that previously these lands were not shown as FTL lands and were shown as your lands, Patada, Passbook or anything? You have enclosed.
fact without similar matter is filed, that is, today it is for final year, page number 59. Regarding the same.
What plus matter means? That if you are not arguing it, just standing up like this doesn't help. We will record that not arguing anything, standing, looking at us, therefore no case. We will dismiss it.
Kindly see page number 76. This is the case of Malcolm Chapter. This is the Malcolm Chapter 7.29. in village map also, page number 77. The Mattanzar extent is shown into the extent of survey number 18.
This is 7.29 of what, sir?
Survey number 18. In village map
These
also.
arguments, others are waiting, right?
Yes, in
We
village
don't
map
have to
also.
continue with your case till further.
In village map
It's
also.
for admission.
In village map also.
You don't have a case, that's why you are not speaking it.
Minimum level is shown as the extent of survey number 18. Is 5. Coordinates have even hectare 50.
14% submits this petition, the 14% has still the preliminary application dated 3,014 issued by HMD. But percent of 1.8 from this post. The Bahani, right, the national extent people submit that the SDL level of the land agriculture tank has been tagged as given extent of 7 and is situated on survey number 18. And the village, that is the village map. But related is only 8%. Yes. Yes, but interesting part. Given by the action of responded period 4, would be instead of proceedings under section 14 of the Circulation Act, appeal 2019 9/69. Before that, I would like to say about facts. Earlier, they have initiated at section 14 of the SITI Act. For the season of the industrial concern, was challenging the order dated 15/6/23. What we are trying to tell you that inflow of law laid down by 2019 9/60. Yes, 94 appeal under section 7. Please go. Yes. This petition from a petitioner has said the value of the order dated 15/6/2023 passed by the is petitioner files an appeal along with an application for stay. Yet recovery tribunals and consider the application for stay is petition. Apply. Yesterday, lots of similar yes. Mr. Okay. Give it. Give it. Same order. 7 8 and similar. Same order. 9 is similar. We got to picture.
PG management side.
PD. 7 8. It is same order that we have given. 9 is PG. Admission to meet PG. That's all. Seriously. But who's expert? That is taken up that thinking. The one will go to make one submission. It's got the peer. You are not the party. If you are not the peer for petitioner, this is not publicity interest litigation. You are respondent. Willing to take an action. I am for the victim. We have filed a petition which was listed before the other court. The court has directed to oppose the matter for the attentively submission. Which WP number 23092 of 23092 of 2020. The victim has preferred a different justice. So when the learned sequence is passed on, it was listed today as number 70 before the other court. The other court has directed to make a submission for this order in court again, but the item number 70, the order has been passed off just oral. Just stating that both the matter is to make a submission. We will just come on. Yes, but do the certain. Nothing to argue. Yes. Nothing to argue. Nothing to argue. This petition has been registered on the communication. Open attack, the ruthless rival, my name is Sri Lakshmi.
And in one supply, of entry, there would be of entries of entries of
GD,
GDP.
GD entry.
Logbook is a vehicle, I thought that is logbook is maintained in respect of vehicles, how many kilometers, many kilometers.
The
shall going to be responded shall also will be GP entry of what police station is taken a reflection.
Using a land order.
Yes, on law and order, on of before then comes this complex.
We want to see the CCTV footage of the area from where she was picked up.
Area of testing.
It generally the start of the appellate for launching. I think written synopsis today about kindly answers.
Synopsis has already been published. The vendor came last time.
From now you will appreciate 30th August is approaching. So all these students are waiting, and if your petition is heard, leading to revenue land, we will not get doctors in Telangana. You decide what, but it has come before us only once or twice. I mean, that's why at the outset we genuinely told you the difficulty. That's a part that matter. Ask you the former assistant of this book. Ramakrishna Reddy, he argued for 1 hour and 1 hour more than 30 minutes. Then other councils also argued. We have to hear Mr. So we can pass it over in case you want to wait. Fix a date beyond 33rd. Mr. Vidya over senior council, she simply said that after 30th August, we told him this, told us this, she said any date beyond the 30th.
Same applies to me also. Because that is also a senior council.
No. Yeah, applies to you.
That is online, is a physical board.
Physical code. No. Well, this thing, we say Mr. All the time, my temperament, I can't be serious. So I don't take whatever I say very seriously, that this is the meaning. So otherwise, we will record your submission, fix a date. To argue whatever that you are waiting since 1990. What else?
He responded to the survey.
So
Let it now the request for adjournment, they state. On the ground that synopsis has to be prepared, but I have already prepared the synopsis, applied to them and filed in the court also.
So yes, like
Monday.
then what do you want to do?
Yeah, Monday or not. Yeah.
This is September. Going to learn it. Mark everybody's business, learn it from the minutes of which that she shall say often to opinion, senior correspondence of it. On 23 Monday, 2023. Yes.
Yes, actually, this repetition will not the storing the nearly about 5,000 lorries of nearly about 5,000 lorries of sand in the area of Mantari Peddapalli district, my lord. The petitioner is a ex-single funded window director of the Pax Agriculture Cooperative Society, my lord, and he had no personal interest, my lord, in this subject. The respondent number 7 RK Builders is storing nearly about color photographs.
These are there.
Respondent control this environment of
In addition to issuing notice and testing, we will start imposing costs because you are adding to the litigation of this. People make complaint to you. You don't take any action, they rush you.
and essentially the environment is to why the action has not been taken. I think with some of the grant us a couple of weeks time and the instructions to why the action.
take a report on the when have you made the complaint?
I have dated 28/7/2022, recently 6/3/2023.
You are not a the mining mafia thing.
No,
Why you ask this?
my petition is
No,
also
no.
filed.
Like except for saying public interest litigant, what have you done?
My lord,
Except filing petitions, what have you done?
my petition is
What social work?
executive director with respect to tax filing with the concerned village.
All social worker, environmental activists. What activities have you taken to protect the environment?
My lord, in this, my petitioner has taken
Particular, this is the public interest litigation. And you are to disclose your public debt antecedents, correct?
yes,
We have delivered one judgment, you better go through it. Public interest.
technical direction.
Then amend the petition, what? Supposing if you are saying that social worker, environmental activities. What activities have you taken to protect the environment?
My lord,
How many trees planted? What this thing? What action taken for this thing? Prevent this solution. It's all saying that everybody is a social worker, everybody is an environmental action. You are also social worker. When you do this, when you are doing this case free of cost, you are also social worker giving service petitioner free of cost. And then environment. Meanwhile, you find out they are not issuing notice, but you find out the account for the petitioner place for an started how much time?
2 weeks.
2 weeks back, you enabling to file an affidavit disclosing the activities of the petitioner as a social worker and as an environmental activist. Just after 2 weeks. I can respond. This was when you heard.
Yes, my sir.
You are true with it. What do we are dealing with young people aspiring to be doctors? Matter. Yes. Fourth September. 4th September. I think. Because what we expect is up to 30th August, every day each aspirants will be keep on coming and those cases you will appreciate have to be dealt with.
Doctor said evidence over.
Insult everybody, all of us need doctor here. Society needs doctor. These covers it.
Carriers of all commercial matter. So let's say
Both section. Marking registered down the accident place for some.
from 5th September.
5th September. Yes, okay.
I can make it right now.
parents serve the copy, not the company.
This is an appeal against the art of the. Our founder, right, the Lord said directed notice on the last. Third spot.
Yes, notice.
You want time, he wants time.
He wants time.
How much time? Which day? Here come, tell us.
Already Monday.
Fifth or,
Fifth September.
fifth or twelfth?
Well,
Fifth or twelfth?
fifth. Very come, respondent place for some. Then we get prepare it is in our take place on fifth September.
Right.
Wait, the
Email produced.
yes, it's been fine.
Why it is
So last station you talked about that is the that's still fine. Others they played that that case. Got the
the ex party thing, right?
yes. Got so
Shall we take it up at the end of question here?
Lord have the option. Please forgot they have good. The
11th September.
But I should have asked them to know the email copy. But receiving the email copy, I see that there is a missing of email in between, which I have as a counsel to them. So now public I say now. I will produce. Not produce it, I will produce.
Produce. Correspondent. Margaret Lawrence counsel for that the copy of email produced by on behalf of the applicant does not contain a response of the respondent. We will admit it. He said that. It is admitted for you. You admitted for a same hearing. Everything can't be heard. Is for admission and adjudication.
Item 21 MA which is Anik Prasad Dilip.
The last question. Third was
Yes. Oh, mutual record.
that was used by the last question.
Is that the word? Yes. Has been good, right? That last question, you can't get in compliance of the operating.
I think some date when
File application. Yes. That we are asking every file an application if they
they
want
want this matter, but I'm very sorry. Expand the start.
Sorry.
Of course, our season. How to dedicate on
Please file an application against the applicable of
this. We tried to have IH2 of 2020. Australia of responding to. Yes,
any object.
The right of objection, in fact, that is the right party which has to.
This has to be right. Not on item number 2 of 2022, taking into account the nature of proposed amendment and for the reasons stated in the application common duties of. Oh, judgment about what?
one of the launching the matter of society. Seriously, for let's association first of all. The launching wanted to get some report. The last one.
Yes. That is with respect to Milan working with you will.
Maybe
Now isn't it already the issue to the newly added respondent now?
yes, that's what I'm saying.
Yes, the issue of this.
You are taking notice for now district register. No, now we have changed
Change.
the district register.
But then you will take it.
So is the training. What?
Last you put it off.
Maybe it will be from.
How does this discuss? We want to take this opportunity to inform everybody and we have informed in fact from today onwards, auto generating system, auto dating has been implemented in the High Court. And therefore the system where we don't give a date, the system gives the date. No case will remain. So don't worry that court has not given a date, so it will never come. Automatically, and if you want it someday beyond 30th August, feel free to make an application.
Keep your
Let him be served. Let them be first served.
keep your
Next time,
find out.
yes, counter is required in Lordship, and notice is not yet ordered in Lordship in this matter, in item 23. Lordship can order
What
notice.
is the prayer?
But the prayer is Lordship to implement a report that was furnished by the investigative authority, Your Lordship. That was ordered by the Lokayukta, Lordship, where the facts are like this, Your Lordship. A village, Your Lordship, named by.
What is the report, madam?
The report says that this will, may I just submit a few facts, Your Lordship, before that, Your Lordship. Village, Your Lordship, by name of Veerapuram village in Indian Mandal, Your Lordship, in the erstwhile Mehboob district, Your Lordship, comes under the Sri Salem Hydro Power Project, Your Lordship, and the village, Your Lordship, as a result of the backwaters, has been submerged. Your Lordship, and the water has entered the village, Your Lordship. Therefore,
What is the report of director? Again, that question, madam.
the report is that Lordship, the report says,
You tell us your identify.
the report says, Your Lordship, that there is indeed waterlogging in the village. Therefore, this case may be considered, Your Lordship.
This is not PIL.
No, Your Lordship. It is the residents of the village whose houses have been submerged for filing this petition.
Which project?
It is the Srisalem Hydro Power Project. Your Lordship. This Srisalem Hydroelectrical Power Project.
This repetition mark is this. Respondents number 1 and 2 implement the report of the director investigation. One, 2 and 4 accepted by these people who pray for and are granted. This is not invitation card. Say so now. You are still not saying waiting means it's over now. Current council correspondent number 4 submits that she does not want to contest the petition as she is a farmer party. You don't want council for so and so, even though has accepted notice, but has not said anything, therefore it is inferred that he doesn't want to fight council. He should notice to remaining unserved personal service bank.
May I request your AD, if Your Lordship, so please, the senior council
Nothing, you have argued it so well. We are appointing you as senior counsel in this case. You have argued it so well. So senior counsel. You are senior counsel. We are that division which is appointing as senior in this case. Yes. Sir, don't. So I'm still not saying that please, I want time to fight counter, you are not saying. I have said that he stood up and looked at the court and did not say anything, therefore the presumption is that he doesn't want to fight counter, this is the order I have dictated. So despite that, you are not saying anything. Delete everything, 1 and 2. Or delete 4 also. Don't say much. Otherwise, we will record it. Everything, nothing, no private conversation is taking place. This is all court, and this is what you are saying. I am a formal party. So, what does that mean? You say that we are not concerned formal or informal party, but you should say whether you want to file counter or not. If you don't want to, don't say formal party. Leaving it like so, asking. So, advice, seeking an advice from the court whether I should file counter. Correct? Don't do it. You have been engaged by respondent number 4 for this thing, depending on your legal expert. Don't in turn ask whether I should file the return counter. Don't file. Say so. Or don't say anything. We were not saying anything. We had directed issues of notice. you people stood up and looking at us. We will say 2 persons stood up looking at the board and spoke. 1 into Mr. 1 into this one is granted. 4 weeks time. She is not praying like this right now. We will conclude that doctors too. Doctors are see, Mr. One like how many in your council, Telangana State Bar Council on the road? No, no, on the road generally I am asking. Forget about the fix. 6,000. 30,000 actually. And 25 more will be added. And how many doctors?
But all India one exam is fixed day, but they rule one more year. They've already lost 6 months. And some of the candidates, Maharashtra.
Our examination is 5th of February. No, Mr. We see right now, if you want, we can't hear it because we are in the midst of a partner matter. We will pass it over. And if time permits, we will hear it.
Instead of passing first it was. For the other course and
This matter may take some time, medical back. Let it be in the past over. If it is not today, it will reach tomorrow. Whenever the list of the medical matters are over, we can take up this. Choice is yours. We have no problem in giving Thursday, but the thing it will go down. Again, we will make a complaint.
Let it be passed.
On Thursday, we were just wondering, we were having a little doubt that Thursday we will be speaking for the whole day. So we can take up your case on Thursday. Correct? Yes, perfect. He is ready, charts, etc. Here given. And we have noted down what is the control. Yes, you can just 2 pages on not sufficient, 1, 2, 3. That's it. It doesn't take much of a time.
Even other place for your not much of it.
No. We have assistants beside PG, right? Who also discuss the council, please prepare synopsis, official 1, 2, 3, 4, case law, which paragraph. And with that, we are sure that we will be able to conclude it very quickly. Yes. 24, 8, 23. 24 so far. Running down for the party undertake to file a synopsis. The 4th August.
Station Jagan Madhav Rao.
After the not pray for this granted 4 weeks further time we will fight for. You right? It is that it's for you. The question was one more. Nobody appears for the petitioner. Compare it to the like nobody appears for our petition. You people can't see that we have filled these boards. Yeah, I mean, you must switch sides this time. No good. Sir, we keep on sitting. you have the liberty to move. You keep on moving from here to there in the white. Good to move in and up. Good to continuously keep on. Yes. But so he has to fight. He has to argue. What? Sir. Really? What we can, you know, what is it about? That they only tell us that Lokai has regarding we say that they are not giving a to the section B. And only one of the property judgment correct. Is there is Telangana state Lokai Act? Yes. Get that indicate service, you can pass an order. We will transfer all our service matters to you. It's not like that. It's not like that. It's not like that. I don't want to like that. Because I'm not 96 section 7 of the Act. Section 7. Based on under what what is right. Section 7. Matters which may be investigated. Then, subclass 4. Subclass 4. Then any other public service belonging to the in behalf of the consultant in the case where a complaint involving investigation is made in respect to such action or to the opinion of the subject matter litigation. Subject to the following act, may investigate any action which is taken by or with the general or specific approach. It says any can look at any investigation methods and section 8 and all the subclass notwithstanding anything investigate any allegation in respect of any action to be related to the family. Whether or not the losses will come to section 8 which says which cannot investigate. Section 8 matters and subjects not subject to investigation to look at. I do not come under that. And only in respect of no investigation. I do not come under that. You say that we fall under section 7.4. Yes. Yes. So regarding I have made an allegation to look at that, but evidence was not fake. There is an allegation against the not fake. So that was sort of investigation. Only a BH local notice has been for activity. At that stage they have come here. The question of jurisdiction was not raised before the local actor. At any stage they participated. Because the law local actor felt considered the commissioner to come and explain the record. Why it was not fit at that stage they have approved the law. Is he a retired employee of your institution? Yes, sir. Application before the local actor. No. Forget about it. They are asking you something. Is he a retired employee of your no? No servant, master servant relationship is that you don't know. I respect. Work in a organization for some time. As per the complaint, you know. They are asking something. These are the forget about it. So the complaint not. Then it's not that. Around the responsibility of flow of the late employee was working in common fitting. It's zero. Yes. servant was not there in law. Even for 5 years, and he left the service. No, in 1981. Left the service and continued to be as 1981. But the considered distance with. No order is passed. No order is passed. Further, he is not entitled to any terminal credit. He is not entitled to recover the amount from the widow. Right. So your rate during his lifetime is not made any application to reinstate into service. Sorry, not made any complaint variable. Even for the so we are trying to fighting corporation, fighting against the widow. No, it's not just. Therefore, you are trying to explore the possibility of the navigable settlement of this. Could have, I mean, we don't know. You are told that this is, but supposing if you would have said that we are agreeing to pay 50,000. So we could have done that and then decide the legal question whether mobile jurisdiction or not. That we are not saying that we are saying that she is not at all entitled to anything. On the other hand, you are entitled to recover amount from the widow. No, I am not saying that. What? We are only saying it is not entitled. Because it's a disputed question of fact, which can be decided by regular tribunal or a proof. Why necessarily wasting time? You don't want widow to get anything. No, that is I don't find a repetition to whatever if he was a workman approach labor code seek a reference. Obviously, otherwise if you want us to decide, we will decide. But he has power under section 7(4). Well, but just in 1 minute, let us assume that your case falls under section 7(4). Let it other sector no. But see, it says public servant. You are not public servant. Sir, you doesn't say legal representative of public servant. Expression public servant, which is into take your case expression public servant used under section 7(1) who is sons, daughters, widow, stepsons, stepmother, everything. And what happens after profile conducts an inquiry? This is still a power to conduct an inquiry. What happens? They give a name of the section. The next section should be and also the look at the what you do. So, Mr. It's not even a report. Like this is not even an order, right? The report. Government may accept it, may not accept it. Why move before a non-adjudicatory forum and spend time there, chilling out, and then thereafter, when it is not implemented, then file a petition to enforce the report of loci before this court. What you will do? Lord Cecilia, Lord section 7(1), we will decide the legal question. It's not that wisdom based legal on it, but still, if it is not, we thought of it because we spoke so much because it is a window. Section 7(4)(c) and which other section 7(1)(4) and 8 are which other provision your complaint falls. No, first of all, it has to be dealt with by section 7. So we can't put savings on. Yes. So let's get that. There's an all-inclusive law. The provisions are applied to clear the enactment of rule of law. What we say. So how do you read section 7(1)? Read it again. Subject to provisions of the Act, the loci may investigate any action which is taken by or with the general or the specific approval or at the behest of public servant. What is the action taken against you? No action taken. Your claim is for gratuity and retirement dues. So this is the initiation of an act. Sitting on the complaint is only without jurisdiction. The power is loci may investigate any action which is taken by or with the general or specific approval of or at the behest of any other public servant belonging to and so. Action of a public servant or the determinate clause mentioned, classes mentioned there is, can be investigated by the obviously within the expression, this expression, the claim for payment of gratuity and indemnity does not fit it because it's inaction. They are not paying. So that can't be into by the try to try to settle the dispute. And human beings are telling you, right? Try to settle the dispute. It will be allowed. Correct. What is there only condition was there. Look at the we are Madam, I also with it. Madam, the question that regarding service jurisprudence, look at that doesn't have jurisdiction. That is, we are interpreting section 7 to say. No, no, I also want to have one of a division bench of this honor. Regarding so that whether okay for vacation of stay is made out, why we should or learning from the parties on idea number 4. I will have to lodgement permit by allowing the reflection. Therefore, we say that at this stage, learning comes. Right? If we write it, then we have to write everything because today is the day of PPS 25. Each undergraduate exam. Since it was written for a person. At this stage, learning comes for the petition that the petition be allowed, and the petitioner and the respondent will be granted the ability to take the remedy as may be available to stop. Therefore, in this paragraph, as stated, comma, the really. Very many companies have tendency to like think by themselves. You are thinking something right, innovative or original while we are thinking on something about welfare of our country. In a lighter way, we say, don't take it seriously. Yes. Water cannot be cannot be sustained in the form the come at this stage when it comes to this point submit that initiate an action in important law regarding what like liberty as sought for by respondent invitation.
Chief Ravi. Try for the important question. Which type of finding? For what is
One is one comes to the respondent. Thank you.
Damodar Murthy.
Given by
of services.
In the road.
Proof of service.
Then for the government, point number 6 here. In the soup.
Why did this? Vision.
Yes.
Private. The all of them is served.
It's a sole respondent. Respondent.
It is served. What will say with regard to registration of SITI during vacation?
But does with regard to some government starts prior to vacation month. Subsequently, my administration work where the save in my favor. This was very much administrative work.
No, can be done. It's kind of like you can be done. With the civil info practice or whatever. Like this, don't leave everything to us. You are given to assist us.
Yes, sir.
Whether civil code rules of practice or the thing permits such a course of action.
No, payments is separate. There is a circular order passed by the Honorable High Court that no document should be executed during vacation from first week. That is why we have actually taken.
I'll get back to this.
Then it comes for the petition submit that he has taken out action. And one can taken out personal notice to all respondents and assign the proof of service. That void that you should be declared as not right as license is sufficient, right? But we can't grant the we cannot let this issue be adjudicated. That is the relief we will get at the time of hearing some relief. What is that? Okay. What is your submission by the vendor? Stay on the further proceeding should be right. Star is state court. EB proceedings are going on. Let it go on what the worst has happened. Right? The damage has been done, which may be undone depending after the year. Both of them. Let it go on. Nothing to lose now. We finish the, please wait, 15-20 minutes, Mr. Ram, we start here. Others do not wait. Please wait. Someone. 51, 51. 39, 51 is the batch. Mr. Ram. We call that. Vote is not. 3 and 5. Afterwards, I got very clear. We were wondering that where how do you leave flood victims in between and that areas like this.
They didn't find the application so far. The last occasion also taking time for finding the
Special complex.
time from
Give it a pair. That's why we are asked. What happened?
all the others dated 58, 7, 1 year, 28,
You want to say nothing has been complied with that they are just thinking. You want their no, did you visit flood affected areas?
yes, there are one.
When did you go? When did you go? Did you go to flood affected area or sitting in Hyderabad?
No.
Before
Yeah.
as an observer, as an observer of the court, before saying that nothing is done.
I was
No, Sir, place material on record, clearly saying that nothing is done, no amount is paid, just no floods, no trauma relief center is set, so this thing has been provided relief material to. You will obviously say no, but this is not your role in a public interest litigation. We told you. So did you go there and visit affected flood areas and found out? Have you said that I met such and such person who said that this, you don't think that this I really go there?
this family has already been argued. Last occasion, affidavit. Yes. And I have already stated in my page 11. Page 11. My report dated 11/8/2015.
So this today has gone right.
Yes.
He's saying nothing, you didn't do anything. No, flood. Think you did that, I think you did. That's what Mr. Prabhakar was arguing in your absence. So we were just telling him that what about this idea that Mr. Prabhakar himself goes to these areas everywhere and visits and contacts the people and then give a reverse plan report.
Yeah, request from, I've received the details of 47 people have been paid excursions. The other day, I talked about not this, 23 people were paid, so 47 in all have been paid. These camps have also been really vacated.
It will be order last on 70 days. 49 families, 23 families paid, 26 families are have to be identified and this thing, what happened to 26?
47 people in total have been paid. So today's report which I received, 47 in total have been paid. So one is
The words, to be simple in terms of order. You had said on the last day of the layers of maybe 26 families are yet to be identified. So now today you say that 24 families have been identified.
Individual proceedings have been issued, bonds have been sanctioned.
But we get talk, we were not about what about rates, heavy rains from 18 and
Nothing has been so severe, but whatever the request of the
Bakari didn't that all.
the
No rains, he is denying that no rains also.
warnings have also been issued for taking care. The legislation is putting in place, but
No, just let's about it, one thing we want to say. This one, this is, that's all right. But why, in case you have to fight the PIA, with a smile, people. Always find correct, but we will, this thing, if we take on, he is not denying this. And he Yes, Mr. You even said that you are not finding affidavit, only making statements and getting away. That's what.
When it is there, it is there.
When shall we, you will file it today, Mr. Prabhakar, when should be this?
Submit affidavit without explanation from by way of affidavit. Getting all substantial details.
Yes, here,
One of the person that we did yesterday, that also yesterday,
what about the other?
the other person is not traceable at all. Person was here, but
He speaks to Mr. Prabhakar. How can you say? Should be prompting for that some principal person contacts Mr. Prabhakar and tells him or knows that.
They are people in this.
I asked my friend to share the details with me.
But last time he has given.
Yes, last week, yes.
But you don't know how to. He said one has is ratified in that way. We take it about the public. Today is 29 April.
Section 20 state committee authority chairman is chief secretary.
We don't know. Let it file an application. Yes, you are able to point out when we will require. So we will require him to fight this notice. See, Mr. First of all, you should forget that he is contesting the petition. Don't come up with the mindset that you are whatever we should have is you are to. No. You have to act like an observer. You are what give suggestions. What can we? And best thing is go there. Go to these areas and find out first-hand information. What suggestions you have that please give suggestion.
Give suggestions for avoiding loss of human life if a such a future incident occurs.
By way of
Not affidavit, give a statement, what are the, let us be constructive rather than
Just accusing that no, they are not done, not done.
These are all stated by an apex court in Swaraj Abhiyan case are enclosed here and extracted also. That has not been by them.
we understand. Can you not put it in a statement form and say, this is the suggestion, let us say, one bond has to be built so that the water doesn't get into the village.
Yes.
Means water, is it mentioned in the honorable Supreme Court judgment? It is not mentioned. What would we say? Local, you go to the local distance, get inputs from them as to what are the preventive measures we can take.
We are saying
Suggested.
that all such measures to be taken. No one of it. You have to no constructive role, right? Constructive role in this. Give constructive suggestions which are you are before a court which is willing to implement.
Yes. Yes.
Even if they say yes or no, and we have the power to ensure that they do yes.
Okay, again, don't be so obsessed with the affidavit. One second, don't be so obsessed with the affidavit. Affidavit will support, but suggestions should come in the form of a spreadsheet saying this is the suggestion. This is the law. This is, let us say, water is coming into village. Let us say you have to say that retaining wall has to be constructed. Tell that suggestion. Cause suggestion. It should be in that form.
I will support you for your last. Because one is women loss miller and one other is property. Because now reports are coming from local area flood which flood affected in 5 districts. 16 lakhs hectares of crops were damaged, which were banned in the month of June.
All issues cannot be taken up simultaneously. Right? One by one, we have to first of all, line and
After farm, I will put the last.
Premium bomb figure. The fish that the activity comes back for other previous or past that is food that we find in after it comes to the nutrition subjects that he says. On the file. So now I am seeking a direction for 7. The file counter. We understand that you are a public superintendent person who wants removal of unauthorized construction to date set by 12 PM. We understand your desire. You are going over, you have brought the matter to okay, our notice, now it's our baby. You have lost your focus. Sheila Barsi.
Stay has been granted with this court for the civil judge. That will be 4900 of 2023. 4900 of 2023. That's for the various one. 4900 of 2023. 2023. 23. Same school premises.
Just see that we can mention. Together, but do something so that it can be heard together. So, an application that intervention, right? You understand? That stays located while an application for analogous hearing so that we can pass an order. Right? So there are very much easy for the new submits that on account of an easy order passed by them to move the part of what we are taking the TPO of the submission, learn it out for the petition submit that is already find applications thinking effect. And as what vacation of stay action by an application vacation of stay. You further submits as this petition also that will be granted. Changes then including to move an application for analogous hearing for the WP number 4900 part 23 from the district. For WP also there. For 3 months is fine. For 3 months is fine. Who will to find out.
The authorized issue of on a five of the batch. Five of a sample is set up for 1 week time.
You are pollution control
Private individual against the allegations that are appearing to the pollution control board matter. As of
you are operating without the environment
clear, that is the complaint which I have not, I have taken the environment and there is a real on state level impact not being subsequently there is also 2023 terms of reference already issued under violation category. We are in the process of getting compliance. A consent for operation has also been obtained in the month of December 2020. The violation as such having operated without the necessary compliances is now being prosecuted by the department and we are taking steps to come within the compliance. The complaint will, insofar as mining is concerned, most of the mineral being supplied government is not permission appearing in
This matter, we have already issued closure orders and the industry has not been closed. Yes,
we have stopped operations for getting
down because the Telangana has been. Battle is fighting. Yes, you know it. I do. We are talking about this. We must laugh and smile also. Don't be serious. It's a public interest. We have taken note of. We are really. We knew that before you could say. We knew that we should write vehemently opposed by the petition and submitted that environmental clearance be granted to him. State environmental clearance be granted to the petitioner. Then it council correspondence to it 12 and 12. How much time? 3 weeks time. 3 weeks time to get it by cost. Right. It's 3 weeks time for filing order. Serious issue. Serious. For who submits that the investigation has already commenced. However, the press on this matter. So there was a tax amount 15,623. What by this code to use or with the code. Absolutely. What has happened there? But there are no company. For instance, taking the your interrogation carrying he was captured. Third degree murder was Miller because he was not protected. And that's so if they count events subsequent to 15/6/23 on records, 19/6 till 9 years. He was called for till 9 2020. Well, I mean, after 15/6, no notice was the issue. No summons were issued. Right? Awesome. He is ready to cooperate. You are speaking. So this factor is nothing. There is a picture. Unfortunate that there is a direction by a bench of this court on 15/6/2023 to the petitioner asking him to cooperate. He is willing to appear. And you are not doing anything because of pendency of petition. They have categorically stated that we will record everything in CCTV. They will record your statement in CCTV. They will record the police. Because I think even he went to hospital 90 days taking picture because we find it. Patient and knowledge, second patient and knowledge, history of trauma, here and peace, very easy also for a minute to hospital. He will not pay. The other someone to talk for any person regard to state. He is not accused by the time. But the info section 19 of the money law. They record is concerned by the there are no investor who were subjected to you are willing to appear, there is CCTV surveillance, right? That would be clear. And the person who is products as a witness, what they are doing in a they won't be in time in writing. It's at the CCTV now. Yes. Then you are given, let it be recorded first. When will you appear? When will you, Mr. When do you want him to appear? Instructions. CBA norm 40. Submitted that. CBA norm 40. That so then CBA norm 40 by inviting their this is called MSC. So outpatient ticket. Which by Gandhi also submitted that the petition appeared before officer at 9/2022, where it was suspected this behavior by the ED officer. However, learned CBM comes for the subjects that the minister 500. Monday only date, right? Or on that date it will appear. You will be interrogation will be addressed in CTV, correct?
Yes. Anytime. Is what's an issue? How many issues is that enough?
Delete that. Phase one. Carried out this submission is already been recorded, right? The order dated, form written, but don't write it again. Form written, yes. The rest in this place for a judgment delete. Few of submissions made and taking into account the readiness and willingness of the petitioner to object investigation. They won't be ED under CCTV surveillance, it is directed that ED shall issue a notice to the petitioner for his appearance. It is to print that the petitioner shall appear for the of the enforcement directorate on the said date. The investigation of the petitioner as undertaken by respondents before recorded in the order dated recorded in the order dated January 2023. 30th January 2023, moment that we carried out this stuff.
Yes, 747 hours. We are seeking only now. So when we write application under the part 16, that will select 24 other issues. Obviously, not a part of the IA is not doing it.
They can't. We have to stop this practice of maintaining the we consider it.
Here, there is a statement of case of Dr. Sangli. Why the being is this will resist takes subjection. An operator will be provided a step
That's what it is. But there is telling that it's always subject to orders. Okay, it should not, ideally speaking, it would be well advised to word it differently. But it's always subject to order. You have challenged the validity of various provisions. Whether challenge survives in view of judgment of Honorable Supreme Court.
that we may not be.
Huh?
We may not be.
Once the validity has been appended, it can't be any especially by us, it can't be done. So then what does this thing, what remains? For actions. So with regard to challenge, we will apprise us on the next date of the in the light of decision of which the judgment citation 2023. Yes. And you part yes, it's online. See, 929. 929. 929. And your form of like and review part is also over. Review has also been decided. So matter is completely not decided. Review what happened? Pending is the matter from the data okay, not the just fully the last law that order. By P of by P of yeah. The next year comes from the readily submits that the all these rules and provisions have been updated, right? No, it's 5 minutes regard to the quorum. That's pending on the same time. Quorum is not no, but this judgment, which is the 2022, all the act has been made to be, but what are the quorum is but no, as a whole act has been updated. Really fairly submitted. The validity of the email act has been updated, has already been updated by Honorable Supreme Court H1 2022, SITI on 9/9/29 to stop view of decision of Honorable comma and well as taking into law laid down by taking into account the law laid down by Honorable Supreme Court Act in 1989 volume 3 SC 151, where it has been said that once the validity parties once the validity of a provision has been comma, the same cannot be challenged on any additional grounds, comma, the recipient for the can address this code on the proceedings, right? The next step. And is the 151 to get the names of parties. 89 3 SSC 151 is a proposition that once the validity of a provision has been upheld, you cannot make a subsequent challenge on new ground saying that no, this ground I am challenging additional ground or ground which to have been taken and confirmed. Doctrine of finality of litigation, and more so in this case because it's Honorable Supreme Court which is binding under Article 140. Please examine.
For your lordships, it's related to the group for notification, your lordship.
2020 notification was issued. What happened?
Your lordships, the group for notification, lordships. We are
Has been
it's not your lordship. It is not, it's not been stated.
you understand the question put right by the court. What is the status of recruitment process as of now? Because 1 year and how many months?
I
Six
instructed,
months.
I instructed your lordships that next month or something, they will come up with the results, your lordships. They'll come up with the results.
Let them file counter.
Your lordships,
Let them file counter.
your lordships, let them fight. This is the.
Meanwhile, they should be restrained from declaring the result.
Yes, your lordships, because here is the thing. I don't take too much of your lordships' time. The group for.
We are not going to stay.
Not the. Here, the issue is about the village revenue officers, your lordships, where in spite of abolishing the village revenue officer, driven them out of their department, in the group for notification, after perjuring in this honorable court that there are no more vacancies for the same, they once again issue the notification under group 4 in the revenue department in the same cadre. My specific contention and my specific challenge is only the revenue department, the numbers of groups there. That is 1200 lodges. Only that, not the entire notification. Here, after, if I may, I'll just take 3 pages, your lordships. I'll just take your lordships, 3 pages.
All doctors are engaged. All candidates who get into the MBBS course are waiting for you.
Yes, your lordship. That is why your lordship will allow me
If
to
you
wait.
want to pass any interim order, we will say that 3 pages and all that, no case for inclusion relief at this stage is made up. We are saying that let them fight now.
And your
Any
lordship,
action-
any action is
Always-
subject to the outcome.
We will not say so, madam.
Yes, I understand.
You know,
Yes, your lordship, I understand.
that you have said, we fight this petition 22, all action thereafter is subject to result of.
And then pursued in court, your lordship. Pursued in court and then.
Income, Mr. Madam.
First rest. Next time.
I'm not finding this complaint.
It's the
We
fifth
have
time,
to
your
follow
lordship.
sort of a practice that 1 year, until this 1 year passes, you won't fight the counter, stop that practice. You can be also right.
And the 3 weeks, your lordship, 5.
Fight with 3 weeks. It is made clear that in case counter is not right, on or before can take a clear stand. Counter. The state counter is taking on behalf of. In a period of.
May I please, Lordship? Let the petitioner
Can be done for filing a report with respond number 1 will be fine.
Milad, the notice was issued Milad in March. They sought Milad 2 times Milad a time for filing counter. The 4th respondent, 5th respondent for junior to the petitioner. And Milad, to victimize the Milad petitioner, the government posted the petitioner Milad Vanaparthi, where there is no surgery facility available. Is super specialty in pediatric surgery. That is seen.
We are granting time to file counter. It can't be heard without counter.
Milad, they have taken twice, Milad, the people working Milad nearly 3 kilometers distance only. His director, 4th respondent is director, enjoying Milad the post of director for the last 5 years, even though he's junior.
File a petition seeking a writ of co-warrant to enjoying it. That nobody should enjoy.
Co-warranto also issued Milad, but they are not implemented. This honorable court, land single judge, issued co-warranto, suspended the GO. He is continuing. And all juniors Milad are posted in Hyderabad, where Milad is super specialty. He is Milad having experience in pediatric surgery that is available in Hyderabad. The post Milad Vanaparthi, there is no such facility. Entire Milad, his experience, his knowledge is gone. because of modified intention of respondent number 4. He is the influenced person. He influences the government. First respondent issued without conducting counseling. In all posts, they conducted counseling while giving postings after promotion. But in this case, his own people are posted in Hyderabad, and only because the petitioner seeking his claim for director's post, on in-charge basis is continuing for the last 5 years. One time, that GO was suspended by Len single judge, 2017 itself. But he managed to see that withdraw the writ petition. Again, co-warranto petition was filed. Some the public spirited person. See that how the these people seeking for the last 5 months for filing counter.
Mr. Krishna, if your clients are so vulnerable for withdrawing the writ petition, what they have filed, even after getting an interim order.
No. I am not not my petitioner, not my client. Some other person. 2017, Justice M.S. Ramachandra Rao granted interim suspension of GO, which is contrary to 10. Co-warranto issued very recently. Now, that is one aspect. Now, as per GO 273, they should conduct counseling, for all the posts. But here, if they conduct counseling, I will get posting as a principal in Usmania Medical College to avoid me.
Please listen to us.
Yes, sorry, Sir.
We said, want to show your performance to colleagues around you, you can do it. But when we are asking you some question, you are not answering. We said,
sorry, I am so sorry,
we have
I will tell.
Counter finally.
Finally, short time, they are enjoying because of seeking time. That is only my endeavor, kindly consider.
That order.
62, 63, 64. 62, 63.
Yes, Mr. When have you cut?
What is 64 is 5 or 14 to 16. What? 14. That is for which respondent? Which is a 2, 3, 4.
Sorry, what respondent filed long?
Yes, Mr. And of the school is you are taking up the event of the petition is that in the publication is that you are taking over the land of the school for construction of community hall.
Not me, that respondent is encroaching the land of the school.
Maintain status quo, they are not constructed in community hall.
Why is the photograph?
Due to the stay order, they are not initiated any, so you won't construct. That's not finally counter. You might not count the production.
It's not a basic going on here that we print an invitation card to fight counter. You should say, he has already filed, you should say that he has filed, I want to fight. This is called something effective management of time. Conveniently, we are telling you, not for that, we want to hear other students who are under obligation.
Production can have number 2. Fine.
The counter has been filed on behalf of respondents, but so blurred down from respondents 5 and 6 years from the plastic. Before which time you are able to fight counter remodel shipment.
This lower section is taken up by the people respondent. Behind 45 months.
How are you affected? Agreed, sit down, madam. How are you agreed by continuation of interim order? He has not filed the counter. He is praying for that. You want that petition should be around 2 days, right? He wants that.
You taking some steps. We taking some steps saying GHMC has started construction in our school land, thereby depriving the children of playground. Only when this court has taken up a suo moto, then you are coming and saying all these things. What prevented you from taking steps?
We had, when the school is dilapidated condition, the students are shifted to nearest school. And taking advantage of it,
Do you want us to ask them for personal appearance to explain what they did when the case is being adjourned for counter of 5 and 6? Your land is protected. He has to let him contesting respondent, right? Others are making students, Mr. Unproductive things, don't waste time of the court. 64. Yes.
Administration, we are having a
It comes to court respondent. Two, base current is granted. Time. Six student. Bringing to my last petition. I've stated that on the. I don't know if it is. I see. Okay. 27 wanted to. Go to the regular. I'm trying to report here. Both matter. We can come up with something that is right. Yes. Yes, you are right. Tom. What is it? What is it, Mr. Prasad? Thirtieth August. Afterwards, correct down correspondent submit that they have filed counters. List one report. 6th of September.
My lord, signed 67, I'm appearing for the respondent number 8, your lordship. We've been impeached, your lordship. There is no status report in respect of that particular monument filed, your lordship.
Who has been filed?
The state government as well as the central government.
Yes, Mr. Number 67, Mr. TSHC and Mr.
Stephen also notified.
Currently,
In respect of
pray for and are granted 2 weeks time to enable them to find status report based on what date we have from the paper. Then this will be the order. 67 and then we find it. Like that, As is a public interest litigation, you cannot own the own the board in a PIL, right? So what is happening in all cases? Claiming title of the now court also and will be adjudicated to it. No, but I think this is a PIL. No. Is there anybody asking you to be dispossessed because PIL is not
The question of disposition, madam, this is the resident, madam, staying in nearby.
6th of September? It has been adjourned. 6th of September. Your application will be considered on that day. Like a child in the school, you are required to explain, right? And you are sitting here, and we will say that the company did not say anything, so deliberately you are saying that, see, I had told the court, my client is first doesn't understand, and they are making us like this, what to do. You are not here, right, in Hyderabad, in this meeting. Since yesterday, we are telling that we are taking care of the interest of the students who are seeking admission to NEET course, undergraduate. Last date is 30th August. Do you have a last date? Every time we are coming. fix a date, man. What is the order of content?
Page 10 is simply disposed of, but page 10.
Date,
Page 10.
against the order dated 9/8/2023.
There was no order. Even now, there's no.
Writ petition has been admitted for hearing. So now the challenge to that order is attained finality.
But there's next to the CO which gives 100% reservation.
There is the order passed by.
Page 10 of the IM.
Right? Was 178
along with the UG batch, but it was never listed.
So we see we are not in a position to dispose of the petition because they are not quite counted. Right?
And they get
One minute, but this is yours. Not to the order. The considered liberty that TPS High Court is not in a position. But we have admitted the writ petition only on 9/8 and they are not quite counted. So if you would have been standing there, would you advise us to dispose of the writ petition in view of this order? No. Would have said that, sir, I may be heard. I have a right to fight counter. You cannot deprive me of that right. Just proceed to like this. So then interim arrangement has to be made. What interim arrangement?
Yes. Respect to
What interim arrangement? So therefore, the scope of today's proceeding is to make an interim arrangement. What is it? Interim arrangement. What is it? Non-local candidates.
Yes. These are all local candidates. They're being treated as not local.
We are hearing today, right? But
Those are, but those candidates have stayed outside the state. Here, they have studied only study part. They have done outside the state, except that they are born here, studied, schooling, and they're serving the state now since 10 years. Last 10 years, they're serving the state as civil assistants. But
need to tell us the facts. So what they seek admission to UG course.
teaching, they are already doctors serving the state.
But even all we have to do it right. Take out and write.
You have prepared a notebook.
First, you should give a note.
Page 64 of the IE material.
I hear runs into 64 pages. So you have already this thing you want copy today then. You are again you are on the this thing text line you want the this thing voting pass you have got 20. That's why such a time. I understand.
But I
Yes, there you have to make it out. Here, right? You can't say about it.
page 64 of that.
If you appear before honor, already preparing another SLP, right? Pursuant to interim order, I gave 5. thereafter start dipping. Lighter vein is the you are correct.
64.
So this problem. We wanted statement of facts you have not said.
I'm just showing you how well they are appointed and then how they're being
This
served.
is not what is called. When we give us, ask you to give us synopsis, that you don't refer to page 64 of IE.
This is along with the dates also of their appointment. Since we are here,
We will record now, we will be more cautious. So if you have a tendency to fly away, we will say that you have considered that this petition cannot be decided right. And this is page. We will record and we are examining in terms of order passed by the Honorable Supreme Court what interim arrangement has been made. So this is the interim arrangement page 64.
page 64.
Now, what are the facts? I might transfer that Monday. Is the interim arrangement right? If I counter who are the petitioners, they are who's valued, what they are doctors, survey doctors. We asked him the facts synopsis. He took us to page 64, which is full of dates. Doesn't make any sense for me to read.
Just to support my case that these
So I
are
have to tell the facts. So literally, we have not read it.
well as all.
This is what you want to hear.
First phase of counseling is already over. Second phase is started notifying.
Suspend. No. If you are being these tell us, petitioners are in service candidates.
In service candidates.
When have they completed their MBBS?
Different dates, but
We are
dates
we told you that we are not deciding the read petition finally, but you are not prepared to speak even sentences and you are giving us data. What can be done? We should all record this thing and so that you can challenge this also in SLP that it is wrongly recorded. Right? Tell us what are the what we told you twice that this is listed for interim orders, therefore we have not read it. Every other case we read for admission. This is what you want to hear that the court has not read it. So maybe we take it up tomorrow, then we will read it and we will not ask you anything. Let me find tomorrow at home because we have not done our duty. We ask you simple question. What are the facts? You are saying page 60. You don't even want to tell. You want that every page should go through from 1 to 100, 81 and something 83. Not after lunch, right now.
But all petitioners were completed MBBS, and after completing MBBS, they were appointed as contract employees to work as civil assistants. All 8 petitioners. They've been appointed from 2012 in 2018 as contract employees. Then they were inducted. That, but in the year 2018, all of them 29/7/2018.
That is the civil level. There for the purposes of civil level that contract employment or not.
Recruitment as a local candidate.
They were directly recruited as
Civil assistant service on 29/7/2018. On 29/7/2018.
this is what you should have given dates, right? Instead of giving one page. Yes.
But since then they have been working as civil assistant. But these are the reservation quota.
We are ready to appeal for DT.
Yes,
23. In service quota, what is the extent of reservation?
20% of the
20%. 20% clinical subject and non-clinical, right? Then what happened? That's no credit, right? China, okay. What is 20% quota? Then what happens?
Then I blood the geo 155 and you get the blood.
Correct. So what is the interim player? Mr. Now you are appeared in the PG examination, I have not failed.
Your options are here.
Have they failed? We are hearing interim review.
That's the matter. That would be the president's order. Also, will takes into consideration the residents. Apart from that, yes.
What are you claiming? You are claiming to be local content.
So really, as low one,
You are challenging the validity of the code.
Geo 70 you will call the president's order to treat me as a low.
Geo
73 is the 100% reservation. Page 31 of my letter.
which will be have to tell.
Geo 73 is identical to Geo 70, providing 100% reservation to the locals.
We don't know, at least we can't, nothing turns upon 73 so far as I'm concerned, because I'm not conversant by CGO by number. So you want that they should treat you as local.
Yes.
As an interim measure and give admission. And to appear in first round of counseling. When was counseling held? When was held first round of counseling? Not held. When? When held first round of counseling? No, first round of counseling when it was over. Yes, Mr.
Difficulty is, no. Okay. When was the eligible candidates list was displayed? When was that? That was obviously that would be before first round.
First round of counseling was
Yes.
over.
When was it over? At least tell us that.
What did you tell us, Mr. Fraud Petitioner?
Yes.
We don't want any scope this time. No ambiguity in our orders. So now, so you want that a special counseling be held and be admitted to be more treating as local. Even though this rule is yet to be examined. Is the prayer?
But I registered and participated in the counseling, but by treating me as a non-local, and in the case of this geo, there are no seats to be allotted to me. That's my case here. Earlier to this geo, but I was considered as a non-local.
No, one minute. This thing first round of counseling is over, you are not admitted, somebody else has been admitted. Now we will have to, in case you want a relief by an interim order, we will have to disturb admission of those 2 persons or how many 8 persons who have been selected. Will you not require to impede them? Think about it. And where is the second round of counseling?
There are seats available to the in-service candidate. If I am allowed to participate as a local candidate in the second round,
Process. The schedule of counseling has to be announced or we announce here in the written petition that next round at 2:30 PM and petitioner will be admitted.
Petitioners are allowed to participate in the second round. Local candidate. The status is changed to local candidate.
That question will arise when the this thing, when the second round of counting is notified. Secondly, we can hear it provided he files the count. How can we hear the petition filed on 10th of August 23? Days today. Within 12 days, finally. You have not stated the facts before on the report correct. And got an order. Then what is your prayer? The second round of counseling, you should be permitted to participate as a local candidate.
In terms of
This, but existing amendment is this and that.
but even if the amendment is actually good. Even if the amendment stays, the presidential order 4(1)(b), the amendment be considered as local in terms of the residence. Kindly see page 67, the presidential order. 4(1)(b) about
These people are unnecessarily arguing. It's so simple, right? The undergraduate people are unnecessarily arguing for hours together. So simple that they are eligible under presidential order. Then why if you are eligible, you seek a declaration that you are entitled, and then why are you challenging the rule then? Whether rule will prevail or presidential order will prevail.
for the rules for amendment.
We have understood. Yes. This is prayer that in second round of counseling it should be permitted to participate. Yes, ma'am. Right. Petitioners had completed their MBBS courses from their MBBS courses by opting to study foreign countries such as Russia, Spain, China, etc. The petitioner on completion of
there was no order. Very strict, there was no order. There was order.
What you could have done, the my prayer for legal not be considered, please pass an order next day. Right? That's what we are saying. Nothing, you have a right to file a petition. This SLP also, this order also, you have a right to file SLP. And that's why appreciating your predicament, we are saying certainly right copy today. Right? No problem. So, yes. So now we want to hear to after the break. So one more case we take up 69. Supreme Court remand. Yes, you have what? What is the order of remand by the Supreme Court?
Order of the remand can be filed as an order, filed by the record number.
Hey, Basa. Sir, yes. Yes.
The honorable Supreme Court had said that the lines of the PUCL statement not on the the main repetition itself can be disposed of by a lodge. That was the direction.
Please, I must have filed an elaborate order.
When?
After 2 weeks,
No, when they have filed the elaborate form.
27.
27.
28 of like
Are we present? This matter is listed as of the order dated 3rd 11/2020 passed by the number when the order is the book when it comes from the act. When it comes from the submits, petitioner submits that the respondents have filed their detailed counter on 20th July 2023. 1 month ago. He, however, prays for a payment to the police. Right? Reply. Don't want to file that. And to file reply to advice. As reply when we want after. As to this after. Yes.
Okay, last time for question.
Not at 150. When it is 40, you can make a request.
So I'm requesting your lordship. I think the lordship may not take it.
Where do you want that? What's your name? 75, 76, 70.
T. Ramakrishna Rao. Presenting Mr. T. Ramakrishna Rao.
So we are not concerned. What's your name?
I'm T. Balajeshri.
Because number
75, 77.
75.
The lordship may.
What? Going for learned counsel, topics that the argument counsel is about is unwell and has been hospitalized, right? Has been hospitalized. And is being hospitalized. She therefore prays for adjustment. When that? He therefore prays for adjustment. This started. Don't want to make a mention, right? You know, you are standing like this, so this is.
Yes, but I didn't
Want to have, want us to have our lunch, right? But you are standing like this, so please stay back. Why is now waste time? Say, which way? Who's there? No, no, no. Where is the other side?
The side.
Upside. Yes. Basically, the prayer is for a judgment. How then the king 21. Your additional arithmetic. When so marks learning from the absent praise for a judgment. When we case start, say, next after copy of the order is on to the it's gone. When the compounds are not ready, lighter basement, let's start. It's much, Mr. Yes, Mr. Prabhakar Rao. 230. We begin with the bunch.
I can 70 meters. Nothing for R1. Not if you can post up.
What we have to standardize. And then put it on papers and sell it to the. But there's also change in problems.
No, when you want that. Learning comes, academic learning comes for one number one. Learning comes for one number one, place for a judgment. They order to be for that. This stuff.
Hello,
74. Along with the batch, right? Lunch motion, no?
Yes, it's high Miller. I'm for preparing for fun.
74.
Item 74.
What is this W? Ah, city. Yes.
Because I'm preparing for respond number one there. Because time for fight. I'm for
74. This is WA. Ah, yes. So you are for respond number 1.
Yes.
Who appears
I'm
for
for
the appellant? Appellant. He wants time to prepare the case. No counter, writ appeal.
Okay. Some documents.
Whatever. So we will say how much time do you want?
2 weeks.
Mark the presence, learned counsel for the appellant. In any case, this is 2023 matter.
Yes.
We don't know how it is coming up for final hearing. Learned counsel for the appellant prays for adjournment to enable him to prepare the case and argue the same list after 3
Your
weeks.
Lordship may please to say 1 week, my lord. I am appearing for first, second, and sixth and seventh respondent.
No, this is 23 matter. Why it is coming up for hearing?
There is a direction, my lord. There
Why?
is a stay up by this honorable court. My lord. It matter requires an early hearing.
But he said 2 weeks time he needs to prepare.
On his complaint only, we have initiated proceedings, my lord. On his complaint, State Electricity Regulation Board.
When the complainant himself is not bothered, why should you bother?
What he highlighted is true, my lord. Total harm has taken place in this.
They are supporting you.
Yes, I am supporting him.
So why you should need, that's what he says, that when I am supporting the complainant, why he should need 2 weeks time to prepare, that's what he wants to say.
Lies upon me to some documents have to connect on this.
Our connection, our viewers, they say that by roundly showing them on the category.
Yes. You have got away with an order. Yes. From the learned single judge without impleading them. Correct.
Yes.
Power loom. That situation will not alter, mister. No documents can create that lacuna. Either you say that the appellants are not necessary parties and need not be heard, that then only you can succeed. No documents.
That purpose only will have take.
Notices, my lord, that is what.
1 minute.
Yes.
What day? You are not permitting, you all are not permitting Mr. Rao to commence his argument one by one. It's. Thirtieth, 31st.
On humble submission, your lordships, kindly interim order is.
Yes. Interim order is granted on earlier occasion shall continue.
What should?
Despite that, you,
Yes. Yes.
All right.
Hello, sir.
Yes, Mr.
Just a small intervention. The lunch motion has been moved by my counsel.
Mr. Mayur, we will hear that lunch motion after hearing.
Very well, madam. It's connected to item 39 on the same issue which Mr.
You have moved the lunch motion.
Yes, madam. In the morning.
So you agree that it is along with
It's
this
a
bunch,
part
it
of
is
the batch,
decided
similar to the case situation of in which Mr. Ramakrishna Reddy appeared.
which lunch motion, madam? Facts. Madam, write WP number.
WP number is 23265 of
Right. From the averments made in the petition, it is evident that the from the averments made in the petition, the case of the petitioner as pleaded in the writ petition is that he is the native of Hyderabad and has and completed her schooling from class 1 to 8th in a school in Sikandrabad. Sikandrabad. Full stop. The petitioner has completed her 9th and 11th. 9th and 11th. 10th, where were you?
Plus 9th, 10th, 11th, 12th. My mother was
Maharashtra.
Well,
9 to 12.
9 to 12. Because
The petitioner, petitioner has studied from classes 9 to 12th in a school in Mumbai, Maharashtra. Full stop. The mother of the petitioner is an employee of Deputy General, is employed as a Deputy General Manager within - legal in Hindustan Petroleum Corporation. The petitioner appeared in NEET so-and-so examination, UG examination, secured all India rank of 49,263 and state rank of 1338 and 1338. The petitioner was not treated as a local candidate. Thereupon, the petitioner has filed this petition in which validity of which rule? Validity of Rule 3.
Rule 3.
Roman 3 within bracket.
Rule 3 is English B. Capital B. Capital B.
Capital B and which clause?
Clause Total B, my lord.
Yeah.
Total B, my lords. Total B. Total B. Total small B and
all everything. Yes.
Capital B.
We remember your statement whether Mr. Prabhakar keeps his smile after this thing is important,
Yes,
right?
yes.
All along he is smiling and we appreciate that, right?
Yes. They're the state, they should be large.
He is, of course, three of the whatever rules, right? That's it, Mr.
That's covered by the division bench order of the soil.
You have adopted?
Yes.
Learned Senior Council has adopted the submissions made by him in WP number
21788. No, not
21.
Is it?
Your case you are adopting.
Yes.
You have also appeared in one case.
Yes, but there the fact situation were different. Here is a
that's why.
Yes.
That's why we have fact situation in every case can't be same. So that's why we are stating facts separately, right? So therefore you adopt the submissions made by you in WP number.
My lord,
and Mr. Senior Counsel, this person.
21268
of the
21268
of 23.
Yes, 21268. Government of India employee incident of service requiring transfer and therefore arrest.
Madam, write this thing and submits. Adopt the submission of Learned Senior Counsel and do it so and so, and first case, right? 21788, right? And submits that the requirement of residence should not be made applicable to the requirement of residence
that's required under
a requirement of residence
as required under
one requirement of residence for a requirement of residence for study for studying 4 consecutive academic years or for residence for four consecutive years in local area immediately preceding the date of commencement of relevant qualifying examination. Should be read down so as to should be read down in respect of candidates whose parents are members of All India Force, All India Service,
or government central government employees.
The
same would apply because incident of service is transfer.
Central government.
Yes, central government undertakings.
That's it.
I'm so much.
Yes.
Deeply.
Yes.
Submit Lordships. I just refresh the facts in this case, Lord. Another
Which case? Mr. Senior Counsel.
Yes, Lordship.
WP.
WP Millard 21268, Lordship.
WP 21.
268. Now, the petitioner in this case, Lordships, studied her schooling.
Give us a minute. Yes. Yes.
But studied her schooling for first class to 10th class.
Millard
in Hyderabad, the state of Telangana, Millard. And studied Millard her intermediate, 11th and 12th, Millard in Chennai. Millard, as she went along with her parents, Millard, who are working there, Millard, as an IPS officer. Therefore, the petitioner claims local status. Local status, Millard, under Rule 3, Roman 3. Lakshmi, please to see, Millard, Rule 3, Roman 3, Millard. Millard B, small b, Lordships. Small b. And also claims, Millard.
One bit. Which page?
3,
Millard,
3.
page 20. Millard, Rule 3, Roman 3, page 20, Lordship, please. Start Roman 3.
Yes.
Millard, last, Millard. B, capital B, local candidate.
Rule 3, Roman 3.
Capital B.
Capital B, local candidate. Millard A, Millard, Lordship, kindly see A. I just read, Millard A. Petitioner claims local status on the basis of small b. Just read A and B, Millard. And also, Millard seeks local status on the basis of C, Millard the Roman small one. Just read Millard A. Millard, if he has studied in any educational institution in such local area means local. Millard, as the Lordship knows, Millard, before bifurcation of state of Andhra Pradesh, there are 3 local areas. One is Millard Usman University local area, Millard Andhra University local area, and Venkateshwara University local area. That's 3 local areas. Millard, such a local area is referable to the local area where he has studied. Local area is also defined, Millard.
Yes.
But if he has studied in education institution in such a local area for a period of not less than 4 consecutive academic years, ending with the academic year in which he appeared, as the case may be, first appeared in the relevant qualifying examination. The relevant qualifying examination is intermediate for admission into MBBS.
+2 or intermediate.
+2 or intermediate. Millard B, Millard B, Millard R, Millard B arises, Millard, where during the whole or any part of the 4 consecutive academic years ending with academic year in which he appeared, or as the case may be first appeared, for the relevant qualifying examination, he has not studied, he has not studied any educational institutions if he has resided in that local area for a period of not less than 4 years immediately preceding the date of the commencement of the relevant qualifying exam, which he appeared, or as the case may be first appeared. This arises, Lordship, B arises in the cases where he has not studied at all, but resided in the local area.
Correct.
Let's make kindly see me. If a candidate does not fall within the definition of the small a and small b, then the C lots matrix. A candidate, a candidate for admission into the course who is not regarded as a local candidate under class A in relation to any local area. C arises if a candidate studied more than 2 local areas, then C comes into play. If he has studied in education institutions in the state,
when C applies?
C applies in cases where candidate has studied 2 or more local areas. There are 3 local areas in the state.
Candidate has studied in more than one local area.
More than one local area. A candidate for admission into course who is not regarded as a local candidate under class A in relation to any local area, any local area shall, if he has studied in education institution in the state means state of Andhra Pradesh, for a period of not less than 7 consecutive academic years, ending with academic year in which he has appeared, or as case may be first appeared, for the relevant qualifying examination, be regarded as a local candidate in relation to, please, in relation to such local area where he has studied 7 consecutive years, such local area where he or he has studied the maximum period out of the set period of 7 years. One has to study in the state of Andhra Pradesh 7 consecutive years. A in such local area where he or she has studied the maximum period of 7, not set period of 7 years. Not B also. Where the period I study or study in 2 or more local areas are equal. Such local area where he or she studied last in the local period. The petitioner did not study 7 consecutive years to fall under C, C, AB. Then let me kindly see Roman 2 . If during the whole or any part of 7 consecutive academic years, ending with academic year in which he, she appeared as the case may be, first appeared.
Please read C 1A.
Yes, Lord. 1A.
You apply that.
1 apply such a local area. Such a local area where he or she studied maximum period out of the set period of 7 years.
So
local area.
What is the local area?
Local area, 3 local areas.
So you are saying within AP, Telangana, Venkateshwara, you are making a distinction saying they are considered as the local.
3 local
But
areas.
now go back to the definition of a local area. It doesn't indicate that way.
Local area is there. Local area.
But they don't consider it as all that is considered as one local area.
No.
Please read 3. Please read 3 capital Roman 3 capital A.
Roman 3 capital.
Rule of reservation. Please read. All ABC is considered as one local area.
Let's be kindly see, my lord.
It doesn't say each one is considered as one separate local area.
No.
Please read. The local areas means.
Local areas means part of the state comprising district of Adilabad, Hyderabad, Twin Cities, Rangareddy, Karimnagar, Khammam, Medak, Mahbubnagar district, Warangal shall be recorded Usmania University local area.
That is the area. Telangana area is 1.
The part of the state comprising districts of Srikakulam, Vijayanagaram, Visakhapatnam, East Godavari, West Godavari, Krishna, Guntur and Pakasam shall be regarded as Andhra University local area. A part of the state comprising districts of Anantapur, Kurnool, Chittor, Kadapa, Nellore shall be recorded as a Venkateswara University local area. So you are saying, if we understand correctly, please correct us if we are wrong, our understanding. You are saying, let us say out of 7 years, 5 years I studied in Hyderabad, 2 years I go to Guntur. Yes. So that I will be regarded as a local candidate. So Narayana Chaitanya also you will consider me as a local candidate. Yes. Plus 7 consecutive years, one has to study, we have 7 consecutive years, we have to fall under C.
So the speed is not completely, only between the state and the this it's what we want to fix. This is something must study. This is what is seen locally and requirement of the city is the same. One is study, one is the resident, one is study. Similarly, we see and get that one much need to see. This big. When we goes to them, the period taken is 7 years. What is the definition of local? Sorry. Supporting this and consider then supporting the president outputs it would be where what regarded to share limited requirement takes. What the transfer. So what happened that something like my units and learning where we are seeing in the university. I will be considered as a non-local. No, I will be considered as a local in lots of and same with we have basically so the difference 4 years here, 7 years here. So, Mr. Rao, I mean, as we have understood, because that's what matters. So, your contention is that the rule contemplates 3 local areas. Clause B applies to a case where a candidate has studied in one local area. For instance, Osmania University local area for a period of 4 years. That's up. Or if he has been resident of Osmania local university for a period of 4 years, even without any education, without any education, in both the eventuality, he is entitled under this thing rule. Yes. B. Right? Yes, supposing if he is not resident of, he is not covered under this local area. So that contemplates a situation. Yes, supposing take a case where a candidate must have, may have prosecuted the study in Usmania University for a period of 3 years. Yes, sir. And he doesn't, this thing come under clause B because he 4 years, yes, he 1 year short. Yes. Then he goes to Andhra Pradesh local area, like Andhra University local area. Yes, sir. And there he studies for a period of 4 years. Yes. So then he is continuously has studied in Usmania University for a period of 3 years and 4 years in Andhra University local area. So therefore he becomes, according to what this is the impression which we have gathered, he becomes eligible under clause C. Yes. And similarly, if he has resided in 2 local areas for a continuous period of 7 years.
Yes, sir.
Immediately preceding the qualifying examination, then on the basis of his residence also, he becomes entitled. Correct?
Yes, sir. Lords may kindly see, my lord, my counter.
This is what you are trying to say.
Yes, Lords may kindly see the counter, my lord. Counter filed by me, my lord, GOMS number 646.
Counters.
My lord, it is GOMS number 646 is issued by obtaining with the permission of the president, my lord. Lords,
What is
this page 21, lord. It starts from page 21.
Counter. Which case, Mr. Rao?
My counter, my lord, in the same case. In the same case? Yes, lord. Counter is there. Where the rule 3, Roman 3, that is prepared in accordance with the presidential order. Let me kindly see, my lord, the
You are referring to GOMS 646.
646,
Where is it?
page 21, lord, on my counter.
Counter.
Vacate application. Page 21, lordships. Where this GO issued, where with the permission of the government president, under rule, under class 8 of presidential order. For implementation of the presidential order, GO 646 has been issued. Lord, I will not read the entire GO. Lord, this GO, Lord, the up to Lord, the 11, 14, Lord, to 14 refers to about the way in which Lord, the presidential order is to be implemented. Lord, may kindly see the illustrations are there, Lord. Shall I read, Lord, entire GO?
No, whatever is relevant, please.
Lord, may kindly see the page 26, Lord. Illustrations were given, Lord, in the GO. For explaining the circumstances under which the candidate falls.
This is referable to which the provision?
This is
these illustrations are referable to which?
Not the B, B, C, Lordship. To explain the which local area the candidate falls. If he studied more than one local area.
No. There has to be, what we are asking is, there has to be some clause in this order, To which it is the situation explains.
Milord,
Which order? Which order it explains the examples?
Milord, Lord, kindly see, Milord, the class A, B, Lord, A, B. Milord, next page, Lord, kindly see. Yes.
11.
Illustrations were given.
11, page 24.
Milord,
Page 24, Mr. Rao.
Page 24, as para 11. That is with regard to the.
So there the all local candidates defined.
Local candidates defined, Milord. Local candidate, who can compete for unreserved seats. Milord, this class 11 says, who falls, who are permitted, who are entitled to claim unreserved seats. 11 gives an illustration, Milord. 11, I read, Lordships.
Yes.
As clarification being sought on the question as to who should be considered eligible to apply as a candidate belongs to the state of Andhra Pradesh for the purpose of admission to courses of studies offered by education institution subject to control of the state government against 15% available seats kept unreserved in terms of the Andhra Pradesh education institutions regulation of admissions order 1974. The government, after careful consideration, have directed that the following categories of candidates may be treated as eligible to apply for admission to education institutions in the state subject to the control of state government as the candidates belong to the state of Andhra Pradesh against 15% available seats left unreserved in terms of the presidential order. There are all local candidates defined in the presidential order. The candidates who have resided in the state for a period of 10 years, excluding the period of study outside the state, either of whose parents have resided in the state for a total period of 10 years, excluding the period of employment outside the state. 3 million. Candidates who are children of parents who are in the employment of this state or central government, public sector corporation, local bodies, universities, other similar quasi-public institutions within the state. Roman 4. The candidates who are spouses of those in the employment of state, central government, public sector corporations, local bodies, universities, educational institutions recognized by the government, or university, other competent authorities, and similar other quasi-government institutions within the state. It has been decided that the persons in the employment of this state are central government, public sector corporation, local bodies, universities, and other similar quasi-public institutions within the state may be treated as eligible for apply for admission to part-time course of study offered by the education institution in the state subject to the control of state government candidates belonging to the Andhra Pradesh. 13 minutes. Government consider that large majority of cases falling under the above categories, nativity may not be in doubt. The heads of education institutions, other admission authorities may call for appropriate certificate of study, residence, employment in cases of doubt. In 14, in persons or institutions in the memo, 8 cited that the consolidated single self-contained order in supervision of all previous instructions in the subject may be issued, which should be a comprehensive, self-contained, unequivocal order avoiding reference to previous orders. These orders are issued in regard to the circulars of the Andhra Pradesh Education Institution. These are all, Milord, illustrations where, Milord, the non-local candidates who can compete unreserved seats. Lords may kindly see, Milord, the 3, Lords, page 21, 3. Same has been incorporated as in the rules, Milord. I don't want to waste, Milord, to save the time of this honorable.
No. We want to understand, right? What? So, 20.
Rule 3, Lakshmi, please. Page 21, Rule 3.
Rule.
Yeah, ready, Lakshmi. After the coming into force above presidential order.
No, page 21 you are reading.
Page 21, but
paragraph paper book.
Paragraph, yes, paper 3. Paragraph, paper book, blood.
Acha, counter.
Count by count.
Oh, I thought. Yes.
Para 3, my lord. After coming into force the above presidential order, with effect from 1/7/1974, admission to the educational institutions in the entire state are to be made in the light of the provisions of the said order. According to the paragraph 4 of the order, a candidate for admission to any course of study shall be regarded as a local candidate in relation to the local area. Rather than A. Same as it is, my lord. If you have studied in any educational institution or educational institutions in such local area for a period of not less than 4 consecutive academic years ending with academic year in which he appeared, as the case may be, first appeared in the relevant qualifying examination. That is rule 1, rule A, lordships. Just now I read. B, lordships. Where during the whole or any part of the 4 consecutive academic years ending with academic year in which he appeared, or as the case may be, first appeared for the relevant qualifying examination, he has not studied in any educational institution. If he has resided in that local area for a period of not less than 4 years immediately preceding to the date of commencement of the relevant qualifying examination in which he appeared, as the case may be, first appeared. Then 4 lots. Must be noted, paragraph 4A, as extracted above, covers the cases of these candidates who have studied in education institution or educational institution for a period of not less than 4 consecutive academic years, ending with academic year in which he appeared, as the case may be, first appeared in the relevant qualifying examination, while para 4B applies to the cases other candidates. For the purpose of para A, the educational institutions has been denied as a university or any educational institutions recognized by state government or a university or other competent authority. The eligibility of a candidate who has studied during any part of 4 years period in any unrecognized institution will have to be dealt with under para B. While considering the eligibility of a candidate to be regarded as considering as a local candidate under paragraph A of the order by virtue of the 4 consecutive years of study in a local area, it should be noted that reckoning the consecutive academic years of study, any interruption of the period of his study by reason of his failure to pass any examination shall be disregarded. For instance, a candidate who has studied 9th and 10th class and the junior and senior intermediate in institutions of the same local area with a break of 1 year after the 10th class on account of his failure to pass 10th class examination at the first attempt shall be regarded as a local candidate in relation to local area for admission to a degree course in any institution that is.
How is he meeting it by reading this? He's only trying to say that they will not come within this. So, Mr. Rao, what is the submission? Like, we will go through this whole order.
My submission
submission is what?
Well, my submission
So that we can, we will of course read it. But we must know that what context you are reading.
My submission lordship says, my lord. Lord 4A, 4A and 4B, in the presidential order, lordships have seen the rule A and B in the rules.
1 minute. 4A and B.
With the rules.
No, 4A and B of presidential order. 4A and B. 3A and B.
Small A and small B, the rules I have read, my lord.
No, this is order, right? President.
This is GO.
Which order you will
Presidential order is actually page.
No, which?
May I take the workshops to the presidential order?
No. So please tell us the submission so that
Yes,
we
sir.
appreciate. First
My
submission is.
submission is, Milord, if a candidate studied in any educational institutions for consecutive academic years ending with.
That we have understood. Just now we told you.
Please.
No, but this thing is that they are challenging the validity on the ground of that the Supreme Court and all that.
Milord, my submission lordship says, Milord, they are challenging the rule AP is parameter with the presidential order. Milord, they cannot challenge.
Impugned rule is in perimeteria with which clauses?
Milord, presidential order, Milord.
Which clause?
Milord, class 4.
4. Clause 4A and B.
4A and B. I'll come to that aspect about the validity. I just
No. So if you can, we will hear you, of course, Mr. Rao. We have given them so much of time. You will take your own time. But again, we requested them the same way senior counsel yesterday give submission so that we appreciate.
Yes, sir.
So first submission is that this is you about the interpretation. That's correct. We have told you. Impugned rule is in perimeteria with clause A and 4B of Presidential Order of 1974. Therefore,
that Milord.
Therefore,
the challenge to the presidential order.
Challenge to rules.
Rules were challenged. They were in parameteria with the presidential order. Let me kindly see Milord rules.
No, so therefore, challenge to rule must fail.
Fail.
All right. What is?
How it is parameteria? I just submit lotships. Let me kindly see.
We will elaborate. Second submission.
Second submission is let me kindly see page 19 of the writ petition. How it is the parameteria with the presidential order? I want to explain. Page 19, Milord, rule 3. Rule 3, Milord. Eligibility criteria for admission. Milord, admission to various courses in different.
Where?
Rule page 19, rule 3. Eligibility criteria for admission. Admission into various courses in different professional education institutions shall be governed by the rules of admission prescribed herein. The eligibility criteria for admission into medical and dental courses shall be as mentioned below. Nationality or domicile. The candidate should be an Indian national or a person of Indian origin or overseas citizen of India. Cardholders should satisfy local, that's my please to satisfy local, non-local status requirement as laid down the Andhra Pradesh Education Institutions Regulation of Admission Order 1974 and amended in GOM number 646 dated 10/7/1979. The local, non-local status have to be satisfied as contemplated under Presidential Order and GOM number 646. Rule 13A is a parameter with the presidential order. Therefore, any challenge to presidential order, the Honorable Supreme Court has held. The validity has been questioned before the Supreme Court in Sureka case, Kapoor case, and also Babu Rajendra Prasad case.
Presidential order
has been challenged before Supreme Court. And the writ petitions filed therein were dismissed on the ground that the presidential order is made under the Constitution Amendment 374D. 371D. Senior council has chosen, instead of challenging the presidential order, has chosen the rules. Challenge is made to the rules made, my lord, in the admission rules.
So not challenge the presidential order, which is the basis of the rules.
Yes, Lord. Yes, Lord.
All right. So, and what else?
Lord, my submission lordship says, Lord, lordship, please to see your counter.
No. So we will elaborate. So
Therefore, my submission lordship says, the petitioner who has studied, my lord, petitioner admittedly do not fall under 1A, small a, my lord.
This was another submission that we fall under 4.2 something.
A claims, my lord, D, my lord, residence class.
C2, right? C2.
C2 also. C2 also. He has not studied 7 consecutive academic years in the below the Usman University local area. Ending with the academic qualifying exam.
Alternative submission is C2.
C2.
Deciding 7 whole or part of it.
C1 lots. C1.
No, C2.
C2 residence. C2 is the residence. But he has not resided. If you during the whole or any part of 7 consecutive academic years, ending with academic year in which she or appeared as the case may be, first appeared for the relevant qualifying examination, he or she has not studied in educational institution, not studied in any local area, but has resided in the state during the whole or any set period of 7 years, be regarded.
Not study. Not is not study. Because if it is a study, automatically it will go under B.
But here he has studied.
No. What? See, B applies where study 4 years.
Yes.
B2 applies where there is a gap more than that resided in Telangana.
Yes.
Then C1 applies in a different situation. Now C2 doesn't deal with study. So only deals with domicile. So what is required is domicile. Domicile in the state of Telangana consecutive 7 years.
7 consecutive academic years.
We say 7 consecutive academic. So you say the petitioners have not resided in the state 7 consecutive academic years.
Ending with the qualifying examination. Ending with the qualifying examination.
7 consecutive academic years immediately preceding the qualifying examination and therefore not entitled under 4C2.
Yes, Lord.
Correct?
Yes, 5 years he has studied, 2 years in Chennai.
In case of that case,
So yes, got it, Mr. They don't fall because they have not resided for whole of 7 years in 7 consecutive academic years preceding the qualifying examination. Now what next?
Well,
Third submission.
That submission is, my lord.
Or whatever, fourth.
No, Lordship may kindly see my counter at page from.
No, that we will. These are only submissions.
Yes, Lordship.
Now you can elaborate.
Lord, my submission.
Go back to first one.
Lords may kindly see, my lord, page 26, then I will elaborate.
All.
I just read of my counter, my lord, page 26. And these are all illustrations given, my lord, under the JMS number 646, lords. Yes. Page 26 of my counter. Lord, A has studied 3 years in Andhra University.
This is something else in Andhra Pradesh. How do you put 11 study? It will be regulation of population, right? So it's again, according to the DO should to determine or dispel some doubts, but he's saying you can put them get the legal order, not to Andhra order. When she put 371 B, and class 3, now reading on the application. These are three application. All the delivery. All the delivery. So, Mr. This Andhra Pradesh 74 order, how is it relevant for this case?
Because Lords may kindly see local, non-local status.
No. How is it applicable post 2014 is my lord's query.
This is 74 now. 2014. He says one of the arguments you have heard that it doesn't apply after 26 post 26 2014.
The Reorganization Act.
That's why. See, we are dealing with this. I am dealing with reorganization for the first time.
Yes.
So you have to. I mean, so many things may be very clear to you, but you have to bear that in
Section 95. Lords.
95. Hmm.
95, Lord. Equal opportunities. Equal opportunities for quality higher education to all students. In order to ensure equal opportunities for quality higher education to all students in the successor state, the existing admission quotas in all government or private, aided or unaided institutions of higher technical medical education, insofar as it is provided under Article 371D, Article 37 of Constitution, shall continue as such for a period of 10 years, ending with the existing common admissions process, shall continue. 10 years, my lord, ends with, my lord, 16 to
14.
24. 16 to 24. And it starts with 26/2014, ends with 16/2024 lordships. This is the last academic year. But the admission process has to be continued as per the Article 371D of the Constitution of India. Therefore, it is not open to contain the presidential order as no application.
No, whether this order which you are referring has been adopted by state of Telangana or whatever.
The central enactment.
No, VO 1
GO
646.
646, 646 state of Andhra Pradesh. It applies to state of Andhra Pradesh, even successor states.
How?
Because it's a presidential order. It's the permission of the president. It's 646 was given for implementation of the presidential order. Once the presidential order continues, 371D continues, the Article 371 Constitution of India continues for a period of 10 years. The GO 646 also will automatically applies for 10 years. may just read lots of page 26. But by the senior council's contention is maximum period of study. According to the senior council, but 5 years he has studied Usman University, that's in Hyderabad. Therefore, he can be treated as a local candidate. That is not the case, Milord. Let's make kindly see the illustration. That maximum period arises only in cases where he has studied maximum period in any of the three local areas. Not Milord not in Milord the 2 years outside Milord and 5 years in here. Let's make kindly see Milord page 26, example 1 Milord. A studied 3 years in Andhra University local area, 2 years in Usmania University local area, and again 2 years in the Andhra University local area out of 7 years. Are immediately proceeding to the qualifying examination. He does not qualify himself as a local candidate of any area in the state of under Rule 4A of the order.
Local area, any local area.
He will be therefore be treated as a local candidate of Andhra University local area. Since he has studied longest period of 5 years within a period of 7 years before the relevant qualifying examination that local area, right, paragraph 4.2a. 4.2a below presidential order last please.
But Mr. Bhagatara, where do we get a reference to these examples? Because 4.2a refer of not this GO.
GO it is there in the last.
Where is 4.2a in the GO?
Well, let's make kindly say 4 below.
4, yes. There is no 2 in this.
Let's make kindly see the presidential order on that page.
Examples already.
For presidential order starts page 15, Lordships. 1.5. In the counter, in the counter. Counter starts page 15, presidential order. But page 16, let's make kindly see, refers to local areas. Oh.
Yes.
And may I read Lord, page 16, local area, as it is stated in the not the rules, Lord. Local candidate, let's me kindly see, that is 4A, 4B.
So the reference because in the preamble it refers to C7.
Yes. All right. So it refers to this presidential order.
Yes, sir.
Because there is no para here. Correct. 4.2a.
4.2a.
Correct. So we can go to this. Example number 1.
4.2, let's make this 4.2. A candidate, 4.2 as it is, below in the rule, C, lots. 4.2, may I read below page 16, 4.2 below.
Yes.
A candidate for admission to any course of study who is not regarded as a local candidate under paragraph 1 in relation to a local area shall, if he has studied in educational institution in the state for a period of not less than 7 consecutive academic years, ending with academic year in which he or she appeared, as the case may be, must appeared for relevant qualifying examination regarded as a local candidate in relation to such a local area where he has studied for maximum period of study of 7 years. Such a local area. We have 3 local areas where he has studied. That is illustration number 1. Then let's make kindly see illustration number 2, Millard, page 26. Resident part B, lots.
Correct. We have understood. Like See, same thing, 3 year in
Yes.
A university, B, 3 years in B university and 1 year in C university.
Yes.
Also this thing.
The another illustration also. May read below all illustrations.
Please read. So C is this thing, 1 year.
Example 2 lots. We studied in first 3 years in Andhra University local area, page 26 below. Next 3 years in Usman University local area, and thereafter 1 year Sri Venkateswara University local area. He does not qualify himself as a local candidate in any local area in the state under para 141 of the order. He will be therefore be treated as a local candidate of Usman University local area as the last in 2 equal periods within the relevant period of 7 years he studied in that local. Yeah, by para 42A Roman 2. Last study. The presidential order, I take your lordship's presidential order. Roman 2, Millard, page 17. It fits in Millard the 4-2, where the period of study in 2 or more local areas are equal. Such local area where you have studied last in such local area period. Millard, then example 3, like that Millard. C studied for 1 year in Andhra University local area. Then 2 years in Venkateswara University local area, 2 years again in Andhra University local area, 1 year in Venkateswara University local area. Finally, 1 year in the Usman University local area. He does not qualify as a local candidate in any of the local areas in the state of para 1 or para 4. He will be regarded as the local candidate of Venkateswara University local area as the during the last of the equal period of years after completion of periods of study within the relevant 7 years period is studied local area where para 2B Roman 2. These are all the examples that governing where he falls in 3 of the local areas. Therefore, contention of the petitioner, maximum period he has studied Usman University cannot be treated as a local candidate. If he studied 2 years in Andhra University area or the Venkateswara University area, he can be treated as a local candidate in Usman University. But he has not studied. One has to study 7 consecutive years in the state of Andhra Pradesh. Then only it comes maximum period. That is the reason why 4-2 says in the state, 4-2 presidential order states 2. That's why kindly 4-2 says presidential order in the state. Such local area means not any of the local areas.
Presidential order.
Yes. 4-2 says, first please to see. Can read 4-2
Yes, yes.
Page 16
Yes, please.
A candidate for admission to any course of study who is not regarded as a local candidate under subparagraph 1 in relation to any local area shall, if he has studied in education institutes in the state for a period of not less than 7 consecutive academic years, ending with academic year in which he appeared as the case may be, first appeared for relevant qualifying examination, regarded as a local candidate in relation to such a local area where he has studied for a maximum period of set period of 7 years, that the 2 lots where the period of his studies in 2 or more local areas are equal, such local area where he has studied last in such periods, then B comes to residence. Same as stated in the 4-1. If during the whole or any part of 7 consecutive academic years ending with academic in which he appeared as a case may be first appeared for relevant qualifying examination, he has studied in the educational institution in a local area but has resided in the state during the whole or any said period of 7 years, be regarded as a local candidate. But educational institutions also defined below. This means a university or educational institution recognized by state government or university other competent authority. Relevant qualifying examination also defined below. And the recurring the 7 consecutive academic years ending with the candidate has studied. The period of interruption is also stated. The residents, Lakshmi, pleased to see. Last Roman 4, page 17. The question whether any candidate for admission to any course of study as resided in local area shall be determined with reference to the places where the candidate actually resided, not with reference to the residence of his parent or other guardian. The residence of candidate has to be taken into consideration.
One case they said that I have studied in abroad, but my mother is permanent resident.
In another,
Three cases.
Yes, another case, I studied in Rajasthan, but I resided in the 7 consecutive years. She has not studied Millard. She has studied 5 years in the state of Telangana and 2 years in Rajasthan.
No, but resided in
Hyderabad.
That's the reason. Lakshmi, kindly see, residency has not studied. Lakshmi, please to see B.
No. It only says either you reside for 7 years
Or
study.
study.
So I can, being resident here, I can also study.
No.
Line.
Studied at all. That's Lakshmi, kindly see B, Millard. Not studied. Only resided. So we read Millard page 17. If during the whole or any part of the 7 consecutive academic years ending with academic year in which he appeared, as the case may be, first appeared for the relevant qualifying examination, he has not studied in the educational institutions in any local area.
That is what, it is study in the local area, but resided.
Reside. This is also answered by the full bench of the Honorable Court.
Yes.
And how do we read the video which you referred 647? It says this section central government and the vacancy. But so they keep saying everything. Because clear about students which G is
Yes.
Yes.
After kindly see you. Lakshmi, kindly see the example 4, page 26. It relates to residence Lakshmi.
Question whether any candidate.
Yes. D did not study in an educational institution. Lakshmi, kindly see example 4 Lakshmi. D did not study in an educational institution for 1 year due to illness, poverty during the 7 consecutive academic years, ending with academic year in which he appeared, as the case may be, first appeared for relevant examination, but resided in the state during the whole of 7 years of period.
Now we got it, Mr. Rao. So your contention is that even though petitioner may have resided here, but she was prosecuting online course in Rajasthan, and therefore she is not entitled.
He studied here and Rajasthan. He should not study at all.
I mean, it was not open for him to prosecute any course through distance education or everything and online also.
Recognized,
should,
recognized by the,
yes.
That is recognized by the state.
We have understood.
That is answered by the Honorable Supreme Court last full bench of this Honorable Court.
All right.
This is what how does this take care of page 24? Ask him.
Yes. Yes.
Last week, kindly see page 39. The full bench of this Honorable Court below.
No. Before coming to full bench, they see clause 11. Page 24.
Page 24, Roman 3, last 11.3.
11 lessons.
11.3, Roman 3, bottom, last one.
Candidates who are children of parents who are in the employment, there, that is unreserved seats. Candidates are eligible on unreserved seats. That Miller cannot be treated as local, he is not a local candidate. 11 says Miller, who falls under the unreserved category. But 11 I just read that, 11. As a clarifications are being sought.
All India quota, right? All India quota of 15%. Huh?
No. That way.
See, 15% of available seats for unreserved.
That's why 11. Page 24, 11 lordships. A clarification was sought on the question as to who should be considered eligible to apply as a candidate belongs to state of Andhra Pradesh for the purpose of admission into course of study offered by education institutions subject to control of state government against 15%.
So that will be another these concern.
Yes, please.
But para 11 of page 24
applies to 15% of
reference
available
to
seats.
15% unreserved seats only. Not
all right, correct.
But the Lordship kindly see, Lordships are the educational institutions. But if you studied educational institutions, recognized schools can be considered. That what below the para 4 of the 646 says. Once again, I will read para 4 for my benefit, Lordship. Page 22. I must be noted that para A, as extracted above, covers the cases of those candidates who studied in education institution or education institutions for a period of not less than 4 consecutive academic years, ending with the academic year in which he appeared, as the case may be, first appeared in the relevant qualifying examination. While para B applies to the cases of other candidate, for example, para 1 4A education institutions has been denied as a university or education institutions recognized by state of Andhra state government, a university or other competent authority, the eligibility of candidate who has studied during any part of 4 years period as unrecognized institution will have to be dealt with under para 4B. Unrecognized, lots of pleased to see. The candidate who has studied in Rajasthan, studied here up to 10th class in the recognized institutions. That those who residence qualification falls to those candidates who are resided here, studied in unrecognized schools. We residing in the local area, studied unrecognized educational institutions. But these candidates have studied without educational institutions recognized by the state. Therefore, either they have to fall for 1A or if they studied more than the 3 local areas, that maximum the period of their study will in a particular local area. Let's me kindly see the page 39 presidential order, sorry, page 39 full bench judgment. So batch of cases that were dealt with by the full bench of this honorable court. Page 39. Counter affidavit, page 39. Different cases were dealt, my lord, different cases were dealt by the full bench. My lord, insofar as the case which covers the issue before this honorable court in para 6, Lordship, please. Page 43, my lord, para 6. In data bill number 1228 of 2001, it is stated that the appellant has studied from kindergarten to 10th class in Guntur. She studied intermediate in the state of Gujarat. Same reason, as her mother, who was working in State Bank of India, was transferred to state of Gujarat, and she is entitled to be treated as a local candidate of Andhra University area, but the authorities have treated her as a non-local candidate. Therefore, she has also sought for a direction to the respondent to treat her as a local candidate of Andhra University area. Let the full bench dealt with various other cases. The first may kindly see that the page 39. Page 39.
Hmm? 39.
Yes, sir. 39. Another case, WP 889 of 2001. The appellant studied kindergarten to SSC in Guntur. They studied two intermediate course in Gujarat state. Though she secured 1033 rank, she could not get admission as she was treated as a non-local. Mr. Rammohan Rao contended that she is entitled to be treated as a local candidate in respect of Andhra state. And his learned single judge is not correct in holding that she is a non-local candidate. But there are 39 where presidential order was extracted. But page 54. But there is 38 and 39 presidential order. That's my kindly see. Para 40 million extracted below the local non 4142 and also below. Then let me kindly see. Para 41 million. Paragraph 8 of the presidential order empowers, that is 646 million. President to authorize state government to issue instructions for efficient enforcement of presidential order. In accordance with such authorization, the government has issued instructions from time to time, which were consolidated GOMS number 646 dated 10/7 to 1949. Wrong. 79 minutes, that's 79. Paragraph 11 of the said order says that against 15% of allowable seats left unreserved in terms of presidential order, the following categories were treated as eligible to apply for admission to educational institution. The state as a candidate belongs to state of Andhra Pradesh. But these are all illustrations. Lakshmi, please to skip a lot. Yes, I read already. There are 42 minutes. On the analysis of the above, it is clear that a candidate for the purpose of admission to any institution shall be regarded as local candidate.
41, 1 you have read. Please read 2 also.
41, 1 Lakshman.
1 and 2.
All local candidate, that is, and is the 15% unreserved seats. 41 says, Millard, 15% unreserved seats, the following candidates are eligible. That is all local candidates defined in presidential order. The candidates who have resided in the state for total period of 10 years, excluding the period of.
Para 41 may not be like, they are not claim of 15.
They are not claiming. It's only unreserved. Then let's me kindly see para 42. On analysis of the above, it is clear that a candidate for the purpose of admission in any institution shall be regarded as local candidate in relation to a local area under subparagraph 1 of para 4 if she fulfills either class A or class B. Subparagraph 1 or class B is applicable only to the candidates who have not studied in education institutions but have resided in the local area for a period of not less than 4 years immediately preceding the date of commencement of the relevant qualifying examination in which he or she appeared or first appeared since the petitioner studied. Lakshmi, please to see. Since the petitioner studied in education institution, she doesn't come under this class, residence class, because she studied Millard first class to 10th class in Guntur recognized institutions. Therefore, she doesn't fall in the residence class. Then we'll have the 33. In order to be treated as a local candidate in relation to a local area under class A, one must have studied in educational institutions or educational institutions in the local area for a period of not less than 4 consecutive academic years ending with academic year in which or she appeared in the relevant qualifying examination. 44. Admittedly, the applicant did not study of any of the local area in state for a minimum period of 4 consecutive academic years ending with academic year in which she appeared the relevant qualifying examination. 2-year intermediate course, though she happened to study in Guntur from kindergarten to SSC for more than 10 years, she prosecuted her 2 years intermediate course during 98-2000 in state of Gujarat. Since out of the 4 consecutive academic years ending with qualifying examination, the petitioner has studied only 2 years in Guntur district. She cannot be treated as a local candidate for that area in terms of paragraph 1 of 4. 45. However, candidate who is not regarded as a local candidate under para 1 can be treated as a local candidate under subpara 2 if she fulfills either class A or class B. Again, class B is applicable only to the candidate who have not studied in education institution but have resided in the state for a period of not less than 7 consecutive academic years immediately preceding to the date of commencement of relevant qualifying examination in which he or she appeared, the first appeared. Since the petitioner studied in education institution, she doesn't come under that class. That para 46. In order to be treated as a local candidate under class A of subparagraph 2, paragraph 4, one must have studied in educational institutions or educational institutions in the state for a period of not less than 7 consecutive academic years, ending with academic year in which he or she first appeared in the relevant qualifying exam. Such candidates will be regarded as a local candidate in relation to such local area where he has studied for maximum period, total set period of 7 years, to where the period of his or her study in 2 or more local areas are equal. Such local area where the candidate has studied last in such equal periods. Admittedly, the applicant has not fulfilled this class also, as he has not studied for 7 consecutive academic years in the state of Andhra Pradesh. That is important. Ending with the relevant qualifying examination of intermediate. She had studied only 5 years in the state out of 7 consecutive years, ending with qualifying examination. She studied the qualifying examination in Gujarat state. In order to be treated as a local candidate under 4.2, it is essential that she must have studied 7 consecutive academic years ending with the relevant qualifying in the state. 7. Therefore, it is clear that the petitioner has not fulfilled the criteria laid down under class 4, para 4 of the presidential order in order to be treated as a local candidate, either in terms of 1 or para 4.2 who the petitioner did study in the state of Andhra Pradesh for a period of more than 10 years. It's important. Right from the kindergarten to SSC, but in spite of that, she could not be treated as a local candidate in relation to any local areas in the state. Had she studied in the qualifying examination in the state, the matter would have been different. Page 46 million illustration was given. We do not agree with the candidate who is a resident of state of Andhra Pradesh. We do agree, sir. We do agree that a candidate who is the resident of Andhra Pradesh and who has studied the education institution right from kindergarten to SSC in the state except 2 years would not be treated as a local candidate in relation to any of the local areas, whereas it may be possible that a candidate who do not belong to state of Andhra Pradesh but who had studied 4 consecutive academic years in any local area of the state, ending with academic year in which he appeared or first appeared for the relevant qualifying exam, could be regarded as a local candidate, though he is not a resident of Andhra Pradesh and studied only for 4 years in the state. But having regard to Lakshman,
who have argued, Mr. We have understood that these clauses, how they are to be interpreted, 3 different local areas, then clauses B, C contemplate a different situation. But still you have to answer the question with regard to virus of the provisional rule that Supreme Court in that judgment, unreasonable thing, then division bench of Bombay High Court.
That's right. Let Lords may kindly see my senior counsel has relied upon the judgment of the Honorable Supreme Court in a Meenakshi case. That is, the situation is different, Milord, where there was a condition of 2 years of study to a eligibility criteria, where the presidential order has not been considered.
Then division bench of Bombay High Court.
Governing the Milord admissions in the state of Lords may kindly see state of Andhra Pradesh council has relied upon, including state of Telangana and present Andhra Pradesh. The Honorable Supreme Court presidential order is not the subject matter. Validity of the presidential order, where there was a condition of 2 years of study To the Honorable Supreme Court in Meenakshi case. Lord, that is, Lord, 1989, Lord, 3 SEC, page 112, the Meenakshi Malik case. That is a case where, Lord, a
No,
condition.
but this continuous requirement of 2 years of study
There,
was
Lord.
held to be unreasonable.
Unreasonable.
Of course, this presidential order is not involved, but nonetheless, Supreme Court said that this requirement in case of persons belonging to All India service or this thing is unreasonable.
Here, Lord,
So your submission is that that does not apply because
not apply because the
presidential order not considered.
presidential order is nothing but an amendment to the constitution.
Fine, fine. So
Then Lord
one minute, but 1 minute that this thing, how do you say that this thing, they said that it does not apply to persons of All India service?
Yes, Lord. Yes, Lord. Lord, this are, they are relying upon the judgment of this honorable court, Lord, in WP 23160 of 2018.
That is, there is no adjudication.
Lord, yes. But
No
another coordinate bench of this honorable court, Lord, I filed my counter, Lord. In the counter I filed.
No, then you come to Bombay judgment.
Bombay judgment is similar to that of Meenakshi case. Relying upon the Meenakshi case, Bombay judgment was came. That is also, there also the same condition, Lord. 2 years condition. I just say.
Bombay judgment also doesn't apply because
There also, presidential order is not, the validity of presidential order was not an issue before the Bombay High Court.
Meenakshi and presidential order not considered.
Not considered. That is not a presidential order, is not an issue before the either the, but they cannot be an issue at all because it's state of.
So correct. And then what about another judgment?
Lord, they relied upon, Lord, the interim order. Then the court,
that there is no adjudication.
Yes, Lord. Lord, may kindly see my
Petitioner has not been admitted and she has not completed first year of course. Therefore, that order does not apply.
Yes.
Yes.
That was where concession was given by.
That's
So, Lord, may kindly see another coordinate bench of this honorable court. And, Lord, another coordinate bench of the honorable Andhra Pradesh High Court, Lord.
Which coordinate bench of this court first?
Page 50, page 58, Lord. 58.
All. Yes. So what do you say that full bench does not apply? They say for
They say does not apply.
It applies.
They say, Lord, the rules also do not apply.
Oh.
Rules also not in parameter with the president. They say,
all right. Yes.
Lord, my submission lordship says, Lord, it starts page 58, lordships. And considering the full bench judgment, Lord, that page 66, Lord.
All right. So shall we, Mr. We will read it little later, but shall we incorporate your submissions for our memory?
Yes.
Mr. Prabhakar Rao, Learned Counsel for Respondents. On the other hand, 58. Yes.
Dealing with same issue, my lord.
Has held what?
The following, my lord, full bench judgment, my lord.
It is further submitted that another division bench of this court by an order dated 14/12/2020 14/12/2020 passed in WP number 38580/2022 as followed, has dealt with a similar issue, and by following a full bench decision of this court, it so and so Supra has repealed, has held the petitioners in that case who were similarly situated not entitled to any relief.
Another division bench of the Andhra Pradesh
Learned counsel for respondents has also referred to another reference has also been deleted. Reference has also been made to another division bench judgment of Honorable
the Andhra Pradesh High Court.
To the Andhra Pradesh High Court.
68 lords.
In 68 in no, this order is, madam, previous order is 4/11/2022. 4/11. And another division bench judgment of Andhra Pradesh High Court dated 14/12/2020 in WP number 10319/2019 and other connected matters.
Same there also, my lord, 10th class up to 10th class in Andhra.
Right. Yes, that's it. That's now you can read 58.
Yes.
So these are the submissions, right?
Yes, sir.
Now you can read page, or shall we continue?
Tomorrow.
How much time, Mr. Rao?
Just I will read the two judgments.
Two judgments. Okay. Thank you. Acha, you can read at least finish 158.
Yes, sir.
Then one is. Yes, please.
But there the facts is lots of find. Page 59, para 3 lakhs. Para 2 below.
Yes.
3, page 57. It has been contendable to register that we have studied from class 1 to 10 different places of in India. And he has decided to 2 years intermediate course in state of Telangana. He has appeared in 2010, written by so and so, secured so and so. The given some petition is that he is not being considered as a local candidate in the state of Telangana, and thus made him ineligible.
There are three.
That he has studied only intermediate in Telangana. Okay. Then lots may kindly see contentions have been extracted. Lord.
All right.
Then lots may kindly see, my lord. There are 9, my lord.
You can add there this another 2-page printout and give it.
There are 9 lords.
Yes.
The learned counsel for the government are appearing and first respond also brought to the notice of this court a decision rendered by the full bench of this court in Batin Rajasilpa.
Para 10 has relied upon.
Yes, lords. Then lord ended. Then next also same lord.
Same.
Page 68 lords.
Yes.
Andhra Pradesh High Court. The facts, my lord, in para 3, my lord. In the facts in nutshell, that the petitioner studied 12th class to 10th class in Loyola Public School, Nallapadu, Guntur district. After completing his 10th class, joined 11th at Deepal International Residential School, Mysore, completed the 12th class April 2009. After obtaining the certificate from the concern, he applied for the entrance examination conducted by the Medical Council of India, so and so, so and so. Similar is another writ petition, Miller, that page 70. The facts in page 70.
Yes.
Where the petitioner therein, where preschool from UKG to Priyanka School, Miller Rajamandri, where in Andhra Pradesh during the academic year 2004 to 7, the first standard 4th class to where the Gomati International School, Nellore, during the academic year 2007 to 11, the 5th standard, Ben's Discovery School, Nellore. You have further studied at the 6th class to 10th class from English Medium School, Nellore, Andhra Pradesh, doing so and so. The petitioner father was a central government employee, was transferred to Mumbai. The petitioner studied 11th and 12th classes in Mumbai. They are also similar. 2 years similar to the intermediate in Mumbai, where the first to 10th Miller, 2 local areas. 2 local areas. One is Nellore and another is Miller Guntur.
All right.
Para 5, another Miller direct petition facts. Ultimately, Lords may kindly see the issue was incorporated in page 8, Lordships. Then Lords may kindly see the Honorable this division bench has considered. Para 24, Miller full bench. And also clauses of Miller, the various clauses. Local candidates has been defined, extracted Miller.
Yes.
At the end, para 24 Miller.
Full bench.
Full bench has been. And consider that none of the petitioners therein do not fall as a local candidate.
That's all.
That's all.
Thank. Yes, madam. Mr. Anybody else on behalf of respondents? Mr. Prabhakar Rao, Learned Counsel for University.
Yes, sir.
As the university has concluded its submissions, Mr. So-and-so GP for Education, Medical Health has adopted the submissions made on behalf of Mr. Prabhakar Rao, Learned Counsel for the university. Let the writ petition be listed for further hearing for rejoinder submissions on behalf of the petitioners tomorrow. On account of paucity of time, rejoinder submissions on behalf of the petitioners could not commence. Let the writ petition be listed for rejoinder submissions of the petitioners tomorrow. Tomorrow is what date?
Lordship's kind indulgence. Well, I'm not seriously, but Lordship may please note, if a result is declared only, well, as the lunch motion which we have moved, that is in terms of Mr. Ramakrishna Reddy's case, Malad. An interim order is existing in that matter, and the same order to maintain parity be given. I'm only submitting.
Mr. Rao will instruct, right?
Well, after
Being right,
actually
concluding.
Cannot be treated as a local candidate. Any of them cannot be treated as local candidate.
Interim order is there on the same facts to maintain parity.
Mr. Rao, it's virtually like whatever time tomorrow it will be concluded. Yes, whatever time it takes for us to pronounce judgment, that's it.
My lord,
that's what this thing.
Result if declared may become.
We don't know.
My lord, can be declared for one while others are enjoying stay.
Yes. Okay.
My lord, kind permission, my lord. My lord. Item number 49 and 50. Where my lord, NCC is the party, my lord, we need to get a counter by Monday or Tuesday, my lord. NCC, my lord.
Tomorrow. You make a submission tomorrow because nothing is being done like tomorrow we will take it up. Your case should come up, Mr. Rao. Take instructions in her case, cap category. She is unnecessarily tagged with validity of rule. Find out her father is an army officer and there is some delay in obtaining residence certificate. As a one-time measure, if you can do something. So find out what can be done. So if it has not started, you can permit her to submit residence certificate as a special case. Shall not be treated as precedent. Think about it. We don't know. Subject to what is argued. Subject. We don't know. Madam, you are sitting here without reading the petition.
for 3 days. Huh? Better read tonight. No. Read the averments in the petition. He has said so for your benefit. Once we then don't seek an amendment and adjournment, right? You see, Mr. Rao, what he has said. If there is anything to be done, you do it.
This batch